I mentioned that there are three pillars to your successful passage of the customs broker examination. One is classification, which is why it's very important to focus on it. Two is the customs broker rules, part 111, which we talked about. And number three is the entry. And by entry, I'm talking about anything related with the clearance of goods and bringing them into the country. A good way to. So now, starting from today, we are going into this huge topic of entry, which includes many things. But I think the good introduction to this topic would be to focus on the most important form, which is called the entry summary form. Entry summary form is the form that you use to do many things. You can work with the entry summary, unlike with any other form, to as a substitute for example, transportation inbound. You can work with the entry summary to declare various types of entries. The instructions of the entry summary are so thorough that going over just those pieces of data and what they mean and what they represent will give you an idea of what kind of information you must be aware of before you start going deeper into the entry process. So I think this is a good way to start our discussion. And you all have a handout that you received before you walked into the class. It starts out with a form, and entry summary is also synonymous with CBP Form 7501. This form, besides doing entry, you also use it to calculate your duties. You use it in conjunction with your deposit of duties, and you also use it to identify who is the legally liable or legally responsible party, as well as other players which we talked about in the previous class, such as nominal consignee, for example, the customs broker, agent. So let's start with the first one, and this will be the way we're gonna do it is we're gonna go through the topics, right? And we're gonna go. So when I say the block 1, I'm saying this relates to this, and we're gonna go from block 1 all the way through the remainder. I believe it's block, let me see, block 43 and the appendix. And we're gonna talk about, when we're gonna talk about the entry number, right, we're gonna talk about what it means and how to derive it. And then as we go further, keep in mind each block retains to particular box within the form, and you as the customs broker have to fill it out. That's what most of the importers pay money for, is to be able to fill this out correctly. So, and of course, because this is so essential, such an essential building block, it is very heavily tested on the customs examination. Okay, so let's take a look. What's the block? Block 1. Block 1 stands for the entry number. Entry number is 11 digits, and they can be alphanumeric. By alphanumeric, you mostly refer to the first 3 digits. So this is 3, this is 7, this is 1 digits. Okay, so it can be BXA. And then you have 1, 2, 3, 4, 5, 6, 7, and you have 8. for example. Those can be alpha characters, and those alpha characters usually pertain to the broker number. For example, if you are the broker ABC brokerage, ABC customs brokerage. By the way, this is an old term, CHB. It used to be. It stands for Customs House Broker. Custom House Broker. I'm sorry. The customs removed that terminology from most of its regulations. Sometimes you'll see it in the record keeping and throughout, but now they just say customs broker, not customs house. But I still use it because it's a convenient way to abbreviate. So ABC customs house brokerage, if it has a sign BXA, this is used to identify that particular customs brokerage with all its entries. When I see this is like a social security number. Okay, so and that those 3 digits is called the filer code. Okay, 7-digit entry number. The next part of the entry number. This is a numeric number, and it is calculated by the broker. So if you are the licensed customs broker, it is up to you. You can use 1, 2, 3, 4, 5, 6, 7. Nothing wrong with that, except that you use it once, don't use it again. You must use variation, and it is your responsibility as a customs broker to make sure you do not use the number twice, or sometimes it is called you do not recycle the number. That means that you must work out some kind of system that makes sure those numbers are not being reused. And the last one is called the check digit. This check digit is based on a formula, and the formula is listed in Appendix 2. So this form, no, I'm sorry, it should be Appendix 1. So it should be pages 27 through 29. So pages 27 through 29 of the instructions. CBP 7501 instructions, the handout that you have, they talk about how to determine a check digit. And we should be, if time allows, we should have some fun exercising, going through the exercise of determining the check digit. Okay? And again, the entry number talks about alphanumeric filer code. The entry number, when we talk about entry number, this is the entry number. Sometimes when we talk about entry number, I talk about the whole thing when you see me through lectures, but when we're going to the specifics of customs will test you on this by asking, for example, whether the broker has a duty to determine the entry number, or customs assigns that entry number. Okay, and which one is false, and you have to pick. For this you just have to know that the customs broker is the one party that is responsible for assigning the entry number, except for in one situation. And it usually pertains to importers, such as one-time importers, who are not used to dealing with the port. They are not registered with the port, it's their first time, and this may be one-time, one-shot deal. So what they do is they come to customs and they ask for the pre-numbered form. And they pay a fee, and customs gives them pre-filled form, and which they use to make the entry, to declare goods. That would be the only exception. It's been tested once or twice, I believe, in the past 5 years, so keep that in mind. That's the one exception. But normally, if you are a customs broker, you usually, remember, by getting a broker permit at the local district port, the permit will give you that number. So once you do that, you can do business in that port. So first is a license. It's part of the essential part of the responsibility of a customs broker is to have a license. Second, to have a permit, and with the permit you get this the filer code. It's automatically assigned. It will be stated on the permit. Once you get that assigned, you figure out your own system how to use the numbering so it doesn't repeat itself, and then usually it's calculated by computers. But what if the computer is down? Usually you can't do business, right? But customs back in the old days, I don't know if they still do that, but teachers used to take our calculators away and not allowing us to use the calculators because we had to do the calculation by hand. They say, what if the calculators, what if you don't have a calculator, you need to do something. And I suppose customs still has that old school mentality, and because they included in Appendix 1, they may test you. In fact, they have been testing you as late as April 2012, I believe. They ask you to compute the check digit based on the formula. So that's Appendix 1, my friends. Appendix 1, page 27 through 29 of the instructions. All right. So that's pretty much all for the I wanted to say about the entry number. Let me see. I went over some questions which have been asked in the past. So I just want to give you an example of the question that pertains to the entry number. Let me see if I can increase it. Oops. Okay. So this is a typical exam question. They ask you which statement is false when referring to filer code. The broker shall use the assigned filer code at the beginning as the beginning 3 characters of the number, those 3 characters, for all CBP entries filed in only the ports, only being the keyword, which are listed and approved on the initial filer code application. And of course you're looking for false. This is false because not only, but you can do it on all the ports. This is true. CBP will assign unique 3 characters, alphanumeric or alpha code, so it can be numbers like 1, 2, 3 as well as letters to all licensed brokers filing CBP entries. And if you file the entry, you have to have a filer code, means you have to have a permit. Otherwise it's difficult for you to file an entry on someone's behalf. CBP shall make available electronically a listing of the filer codes and importers and customs brokers assigned those filer codes. This is true if you go to cbp.gov, then you click on ports, you choose your port, and it will be a listing of brokers, and they will tell you all the filer codes which there are. So this is true. If an importer does not have an assigned entry filer code, or the port director refuses to allow use of assigned entry filer code, which can be if the broker messes up or doesn't pay fees or whatever, the importer or broker shall obtain forms with CBP assigned pre-printed machine readable data entry number with a computer check digit. That's the exception that I was talking about, where you come in and you get pre-assigned number, meaning the broker doesn't have to assign it. So this is true, but only if he has not assigned has no assigned file record, entry file record. When you if you ever go through the application process GFK, when you apply for the permit, I suggest you do it in person, because the lady over there will treat the request to get assigned file record as a separate request. Usually it's done in one shot, but if you do not make the request at that time, you may not get the file record, even though you have a permit. So whenever I said earlier that you you automatically get it, I take that out, because I remember now from my own experience I was asked that question: do you want a file record assigned to you? Yes. Why would I not need a file record? I usually don't file entries. Most of my work deals with post-entry stuff, the ex post facto. So someone messed up, someone made a mistake, or customs was wrongful, or importer was wrongful, they want to come forward and pay extra duties. So filer is already there. My job is to go through laws, regulations, and make an argument and fill out the proper paperwork. I do not need a file record. But some of the customs brokers, their bread and butter is to file entries. So those guys, those entities, they do need the file record. All right. So that's why it is optional. But it's optional. It's also free. Okay. So there is no harm in requesting it at the same time as you file the application. But I don't think it will be tested on an exam. I haven't seen an exam question that says that it must be requested at the time of application. But just keep in mind that whenever say that does not assign, it implies that it's not necessarily assigned at the time of application. Because it might trip you, and because you may say, oh, I took this class and they said that it's assigned at the same time. Not necessarily. If you request it is. So this may cause you to choose a false answer. No. And the E, assistant commissioner. So the guy right under, we're talking about the headquarters level. Commissioner is the top guy, assistant is the second guy. Office of International Trade may review. Office of International Trade, they have various offices within customs agency, and Office of International Trade usually deals with audits of declared entries. So for example, they have privacy branch who deals with confidentiality treatment of importers. Okay, the Office of International Trade deals most of the time with audits, classification, and things like that. May refuse to allow use of assigned entry file record if it is misused by the importer or broker. Yes, if you misuse it, we all know that from the penalty from the customs broker part 111 that the customs has that authority. So this is one example of block 1 entry number being tested on customs broker examination. Any questions before we move on to block 2? Okay, let's move on to block 2. Entry type. Well, this is fun one. So entry type deals with the purpose. Why do you want to bring the stuff in? Because depending on whether you want to bring it in for alterations, for processing, for just to consume it, you have to assign a different number on the CBP form here. This form in this block you have to have some kind of number. Most of the time it's number 1, 0, 1. It's consumption. Consumption meaning to consume, so you go to the grocery store, you go to the department store, you buy stuff, you consume them. Whenever that store brings stuff in, they bring it in for consumption. Then, and notice, they start from the consumption entries start from the 0, informal entries start from 1, warehouse entries start from 2. Underline that, because this will make your life easier when you have to make an answer choice. Sometimes they try to trip you. Customs has been known to ask a lot of questions, especially with the entry type code. So keep that in mind. So consumption, I just told you what it is. Informal used to be $2,000. Now it's subject to exception of, I believe, $2,500. Now it is $250. So now it is $2,500. So the limits have changed. Was 2,000, and this is what you'll be tested, 2,000 or below, subject to certain exceptions, such as chapter 9, I believe is 250. Now 2,500 or below. If you see that the number below this range, below 2,000 or below 2,500, I'm sure that they will test you on 2,000 if they will. Then you may be in the world of informal entry. Keep in mind, anything below $200 is a special section entry, special section 321 of the Tariff Act, 1930 as amended. And if you have that, you do not pay any duties, and you do not need to declare the harmonized tariff number, which eases the administrative burden. You do not need to know classification if it's under 200. Okay. Then we have type 2 entry, which is a warehouse entry. Warehouse. What is warehouse? Well, warehouse is a place where you store stuff. Why would you want to bring stuff to the United States and just to store them in a warehouse? Well, there are several reasons. One reason would be if you cannot if you messed up with your planning and you cannot import because your goods are not properly labeled. You do not bring them, you bring them into the warehouse so you can just put some labeling stickers on it, and then you bring it for the consumption. This would be one reason. Other reason would be if you brought in and the quota period closed, which we'll talk about in a bit, but there are reasons for warehouse entries. So those are the three major types. Other ones not so frequently tested are the garment entries, 51, 52. Sometimes this is a recent trend because a lot of military is being contracted out. So if you have a question dealing with not a government agency but an independent contractor, such as Halliburton, for example, doing the military supplies, then it's a private entity. So you must use 01, 02, 03. And of course, another major type of entry, this one being tested the most, is the immediate transportation. This is a situation where you bring stuff to Miami, but the final destination is Minneapolis, and you know that, and you are located in Minneapolis. You want to clear things in Minneapolis, so you file the immediate transportation entry in Miami. You put it on a railroad or on a truck or on a plane for that matter, and you bring it to Minneapolis and you make clearance in Minneapolis. You would use that immediate transportation entry for that purposes. But let's go back. Let's go back. I want to discuss some more details. The consumption entries. So this would be a good introduction because it is subject to separate discussions. Free and dutiable, okay? Free and dutiable is just what it is you want to consume, you bring stuff from the grocery store, and you are the consumer, or you are the importer which brought it in for the purpose of consumption, and the entry is either free or dutiable. You use entry type 1. This is the most common one. Now becoming less and less common, but was very big about 10 years ago, before 2005. Quota visa. So think about visa. If you are the foreigner, you want to come into the United States, and you hold a, let's say, passport from People's Republic of China. You have to today you have to have a visa from the Department of State. You go to U.S. Embassy, and they give you a visa, right, as a person. So you come into the United States, you go through customs, you show that they look at it and they see the visa in your passport, right, and they say welcome to America. All right. Sometimes they don't, but hopefully they say that. But same thing with the commodities. Some products require visa. If you have a jacket, last time I was wearing a jacket which was made in Vietnam, for example. Vietnam is not a WTO member, World Trade Organization. Because it is not a WTO member, its textile products are subject to quota. You at the very end of HTS you see sometimes 3-digit number like 623. This is a quota category. And for Vietnam, United States says you can only bring so many jackets per year. This is quota, right? How do they administer the quota? They do it through visa. That's why usually quota and visa is used in conjunction. So you obtain a visa for, and there is a process for that, which we'll discuss later, for 20 tons of jackets from Vietnam. You bring them in. If you bring more than 20 tons, then you take it to the warehouse, because you cannot consume it, because you don't have a visa. It's kind of like you coming to the United States without a visa, right? Or you come into the United States with your child, but you forgot to get a visa for your child. So you can come in, but your child can't. Ouch. That's the type of situation. Other types of commodities which are highly sensitive and subject to quota are agricultural commodities. Sugar, for example. We have a heavy corn industry. If you open up a Coca-Cola bottle or any of those soda bottles, I don't see many of you consuming them, but if you look at the label, it's a high fructose corn syrup. There is a reason it says corn syrup, because of the cotton industry influence. Whereas in the 1980s, if you were young enough, you would look at the same bottle, Pepsi bottle, Coca-Cola bottle, it would say sugar. To this day, if you go to Mexico for vacation, take a look at the Pepsi bottle, it should say sugar on it. Okay, not high fructose corn syrup. And that's the reason. It's because the corn lobby, made sure that it's very difficult and very expensive to bring sugar in here, because we want to protect our farmers. At least that's the rubric goes. We want to keep them jobs, so we're going to protect our agriculture. Okay, very popular and becoming more and more so is anti-dumping countervailing duty. This one. It is associated with type 3, and usually anyone hear about anti-dumping or countervailing duty? Anyone? So
from China.
Yeah, Tires? No, that's safeguards. Actually, I think they did a CVD. I think they did. Cool. I remember there were safeguards. Okay, which may be under there. Yeah, I never deal with a safeguard entry. How to? Well, first of all, if it's a safeguard, you cannot bring it in. Okay, you have. If it's a safeguard, it's probably will be subject to visa, to quota limits. You can only bring so many tires per year. I remember. Okay, I remember. I did with safeguard.
There is a difference between the quota and the anti-dumping. Anti-dumping is if, like the USA, they found out the price in China cheaper than. Coming here is cheaper than the price in China. They will use it against. They will put it into international trade to complain and file some.
Yes.
Yes.
So.
To file the complaint.
So anti-dumping duty for pencils. With encased in a rigid sheath. That's what they call it, which is a wooden slat with a graphite core in it. I believe it's 110%, something like that, for People's Republic of China. How can, in addition to other duties, how can the United States of America say that the pencils are subject to, let's say, this is a razor. Those pencils are subject to anti-dumping, for example. What they've done is they did, there are two agencies that administer anti-dumping. So sometimes, and why this is important, because customs will ask you about this. Sometimes they ask you incorrectly, but there is a Department of Commerce, DOC, that's number one. Number two is International Trade Administration. And we know International Trade Administration. And the reason we know, I don't have it up, but because they maintain harmonized tariff schedule. So if you ever went to the online official tariff schedule, like we were today, we went to the official International Trade Administration site. Department of Commerce has sorry, International Trade Commission, ITC, usitc.gov. That's where we'll go for our tariff. Department of Commerce has a subdivision called International Trade Administration, which also has a subdivision called Import Administration. And this agency, this branch, this office within Department of Commerce determines the margin of anti-dumping duty. What does ITC do? ITC determines the injury. There must be an injury to the local pencil industry before anti-dumping duties can be imposed. Even if there is dumping, then our domestic industry must suffer. We must lose jobs. We must close our factories. We must suffer before anti-dumping duty is imposed. So then comes the question of what is anti-dumping duty? How you figure out if there isn't anti-dumping duty? And the way they do that is they play with the concept of normal value. Suppose, and this is Department of Commerce, says that normal value in China for the pencil, and I'm just making a hypothetical, is $2. Okay? $2, let's say, for one pencil. And the price in China is $2 for that one pencil. So this is China, CN, this abbreviation. However, when it comes to the United States, that same $2 pencil costs only $1. That means that what happens to that other dollar? That $1 is being dumped. So $1, if it costs $1, $1 is being dumped. Because $1 is being dumped out of $2, that's 100%, right? That's half of the price. No, 50%, half of the price. So the anti-dumping duty, or ADD, is 50%. Make sense? Okay. Suppose one asks, now I'm not sure if it's 50% or 100%. I think it's 50 because it's half. But if you look at the other way around, it's 100%. I'm not very good into the calculation of anti-dumping duty, and you will not have to be. But I'm talking about just the concept. So when I talk about the anti-dumping, which is huge, it's huge as far as margin is concerned for a variety of products, then you know what you're talking about here. So the next question can be, how can China sell pencils for $2 in its own economy, but for $1 in US market? It doesn't make sense. I mean, it doesn't make sense economically. How can it afford to do that? Government do that?
Yeah.
But that's countervailing duty. If you have a subsidy, government subsidy, that's a world of countervailing which we didn't get to. So government gives you subsidies. So for example, they give you cheap electricity. They give you subsidies in form of land. They give you subsidies in form of building a plant for you. Okay, that's countervailing. Or why are we talking about China? Let's talk about the United States. Boeing, right? The case which has been in WTO. Government buys airplanes, so Airbus alleges, from Boeing at the inflated prices. So it costs, let's say, $200 million to make one Boeing airplane, but the government buys it for $500 million. $300 is subsidy, so one can argue $300 is that part of countervailing duty. Countervailing means you countervail the subsidy, the government subsidy. Now, when I'm talking about anti-dumping, we're not talking about government help.
What does countervailing mean?
Countervailing means you countervail, you offset the government subsidy.
Who offsets it when we buy it?
So let's say, so Flora suggested that to produce a pencil, government of People's Republic of China subsidizes its electricity by, let's say, 10%. If it wouldn't subsidize, it would cost 10% more to produce those pencils. So the countervailing duty imposes 10% by the United States government after it goes through all those mechanics, and that's called CVD.
So when we import pencils from China, we add 10% on top of the duties already?
Mm-hmm.
Oh,
But let me go back to that. Let's take away subsidies. Subsidy is a different concept. That's countervailing. Anti-dumping. So how do they? How can they do that? That's one question that boggled my mind. How can they do that? How can Chinese still be profitable? And without
They don't have to look. I mean, if they have a mass production, they don't have to lower down the price and get the consumption in China. They export out to maintain the high
So the market value in China, I actually had that, have seen that in practice, where I was dealing with a factory. They were making shoes. I think tennis shoes or running shoes or sports shoes, and I went to, I think there was an eBay competitor in China. It's not Alibaba. It was some very popular. Like you have eBay in the United States, but you have Taobao. I think that's it. And yeah, I put in shoes, and I was surprised to find that the price for shoes, if you're like one person buying a pair of shoes, pair of sneakers, let's say in China, was not that much cheaper than in here. Like the shoes that would cost $15 or $20, given plus or minus exchange rates, they would cost $10 or $15 or $20 in the People's Republic of China too. I was surprised by that. Maybe I was looking at the wrong site. I don't know. But I talked to the facility manager, and he said that yes, it is true, because if what you see is you buy them in bulk. That's why you see them for low prices. You buy them in thousands and thousands. But if you come in to knock on the door, you just want one pair, then of course the price would be different for you than for everyone else. So for Chinese people, if they want to buy shoes, they're not that much better off than their United States counterparts, it seems to me. In fact, probably worse, because the wage discrepancy over there is much bigger, meaning that they make less money than here. Although that can be argued, given the current state of the economy. So we go back. So that's one way. Okay, so it is possible to sell at the domestic market at one price and sell at the US market at another price and still be profitable, right? That's possibility, citing shoes. Okay. Another thing that I was getting to is that the concept of normal value, especially when used with respect to People's Republic of China or with respect to Vietnam, there is a concept of non-market economy. And when you have a non-market economy, your value computation is not based on Chinese factors of production, because when you compute the value, usually what Department of Commerce, International Trade Administration, Import Administration does is they look at the factors of production. They look at inputs. It costs so much to deliver the wood. It costs so much to refine the graphite core. It costs so much to pay the labor hours, right? But with non-market economy, you cannot do that, because, as Flora mentioned, those are highly skewed, because People's Republic of China does a lot of subsidies, apparently. Okay, so that's the claim. So what the United States government does, what the Department of Commerce does, is they use what's called the surrogate country. Or, using the modern term, not using customs, they use the avatar. What's the avatar? Anyone seen the movie Avatar? It's this cartoon / movie where there is a certain person who goes into this machine and he became enabled into the other body somehow, and whatever that body does is actually that guy. No one seen Avatar?
I've seen it.
Okay, so that's pretty much the same concept they use. They say, well, we cannot use non-market economy because the numbers are highly skewed. So what we're gonna do is we're gonna use similarly situated economy, such as India, for example, or such as Indonesia, where we consider that economy to be a market. All other things are being equal, like labor cost, the cost of living, the factors of production. We use India, and in India it costs $2 to produce that pencil, even though in China it may cost 90 cents. It costs $2 in India. So this is a normal value for China, based on the numbers derived from India. Okay, and this is how you have such a high percentage, because of course India may not be China, China may not be India, but officially they use surrogate country as in India. So you have 108% margin duty for the pencils, because I believe they used India as a country to determine the normal value for People's Republic of China. So does everyone see how that works? For customs examination purposes, what you need to know is that it's type 3 entry, and the anti-dumping duty is administered by Department of Commerce. They can ask about the International Trade Commission, but the Department of Commerce calculates the margin. Okay?
I have a question.
Yeah.
Sometimes on the exam, they'll ask you questions and they'll add that at the end. Sometimes it's relevant to the question, sometimes they add it just to trick you.
Yeah.
But if you wanted to look it up, what chapter would you refer to for clarification?
Look what up?
On the Code of Federal Regulations.
For anti-dumping,
Yeah.
they only tested it once. It's CFR, so it's Title 19, CFR, believe 200 through 400. So we test from 0 to 199. That's what we're getting tested on. But anti-dumping, this is covered ADD.
So we can't even look it up in our books?
In your books? Probably not, because you're only limited to this.
Okay.
So if I, for example, want to do something, and I've done it, I requested, for example, the scope inquiry from import administration. I think I went to something 351, 19 CFR, 351, maybe not, right, but in 300s range, and to look up the procedures of doing that, and I did it. So yeah, this is the territory of anti-dumping.
I just have one question. If you do a duty drawback, anti-dumping fees are reimbursable?
No, shouldn't be. Off the top of my head, no. Anti-dumping duties are rarely reimbursable at all. If you may have overpaid them by accident, where you shouldn't have to pay them in the first place, then that's a possibility. But I don't believe the drawback is reimbursable. And that can be for the policy reasons, like if you import pencils from China and then you do substituted drawback of the pencils from Mexico.
Right.
So that way you're going around the anti-dumping duty, right?
True.
So for this policy reason, I can see the ways out.
Okay.
You can be sneaky.
Right.
And the policy is usually not to be sneaky, that's why you have the rules and things like that. But there may be a way. I mean, my gut feeling is not, and when we should get hopefully to the drawback discussion, we'll cover that more.
Okay.
But right now, no. The answer is no. So that's anti-dumping. Any questions on anti-dumping? No, the Department of Commerce, Type 3 entry, and the margin is administered by Department of Commerce. Injury is administered by International Trade Administration. Those are the key things.
You said that
Yes.
a lot of question on the anti-dumping.
No, they did it a long time ago, in 2008. No, thank God. I think it's a cool topic because it's very cool because it is one of the ways under the current WTO regime that enables you to protect your own industries. So there was one factory left in Tennessee that produces the flat screens for the television, right? And the only way they were able to stay in business is they made a petition and impose a countervailing duty order for the Chinese flat screens. So that way they could compete, because what the free trade regime does, it forces you to compete on such things as labor costs, right? Well, how can you compete on labor costs where the cost of living is different here as opposed to China or India or Burma? Okay, it's different. So this is not by saying it's a free trade agreement. Okay, this is that doesn't apply. It's fair trade, right? So how can you make it more fair? Well,
I mean now, be realistic. American doesn't really manufacture a lot of things.
It manufactures quite a bit.
Look at the trade.
It switched, yes, it switched more to the service industry, and production, the manufacturing sector is in bad shape, if that's what you mean.
Like a television, what brand is American made now? No, nothing.
No, RCA.
The reason I mentioned that the factory and plant in Tennessee is because it was on PBS. I go to pbs.org and they click on videos and they make a video.
They have the name, but it's made in China, Taiwan, Korea. They are not making in.
So what do you do? What do you do? That's the question. Is what's I mean, you guys made a probably right choice by coming in here and studying for the license, because your jobs cannot be outsourced.
But the point is, they.
If you go to become an engineer to make a TV, your job can be outsourced. If you are the Microsoft certified technician class across the whole.
Really back to the point, why even the American brand, they produce their product in overseas. One of the major reasons is overseas they don't care about the union. In here, you know.
Well, the union.
For example, one of the major obstacles.
Well, look, the union implies that you have a bargaining power, right?
Yeah, exactly.
The problem is that if it increases the cost of making things. If it increases the cost of making things, and you just take yourself out from the worker mentality and put yourself in a board of directors mentality, you have to manage a corporation. If you do not manage it well enough, the other guy will be better off. So you have to compete. You have to compete with other guys, right? So you should think globally, right? You cannot stay your production here if the other if the other companies make a decision, because your job is on a board of directors who make the decision for the business for business or company. You will lose out.
When I look at the Apple, they do things sensible.
So there is no right answer, and we here in America, right? We made well, not only legitimate, but we glorify this capitalism, right? Where the profit-making activity, and we put it oftentimes above many other things, right? Above things such as social structure, social cohesiveness.
Exactly. Why the American
safety
dollar is
net.
getting weak and weak.
Yes.
It's not
So many people, many of my colleagues who are licensed customs brokers, they have this dilemma where they see their communities getting destroyed, but they feel like they participate in this destruction by facilitating the import. And I tell them, but don't feel really bad. You shouldn't feel bad, because this is part of the system, right? So you need to transition yourself somehow. You're in good shape, and I'm telling you guys should be in a good shape, because import-export most likely will not go away. And your job by regulation, they have to be here. They cannot outsource customs brokerage to Canada. Not to say that it will not be ever the case, but I do not see that happening in the near future. So this is bigger questions to keep in mind, definitely. All right. So let's move on. Appraisement. Appraisement entry. Appraisement is when you come to custom. It used to be 30 years ago. It used to be the most popular type of entry. It's when you come to customs and you say, customs, I have this monitor, I have this board, tell me how much duty I need to pay you. And customs will look at it and say, well, pay me 6.5%. Okay? You have customs making determination, or customs making an appraisement. Now it became more difficult with NAFTA, and under NAFTA there was a Modernization Act which shifted the responsibility of classification, and with classification of course you have to make an appraisement too. It's kind of dual concept. More responsibility is shifted to the more responsibility is shifted to the importers. So now to make an appraisement entry you have to jump through many hoops. We'll talk about it in more detail, but now it is not as common as it used to be. But it's there, type 4 entry. Vessel repair. Very rarely seen. You may have it as one of the wrong answer choices, okay? But vessel repair is mostly for the common carriers, vessel operating common carriers, such as Hanjin Shipping, for example. They brought their vessel because it was damaged in a storm or in a fire. For foreign trade zone consumption. So foreign trade zones is another. It's almost like warehouses, okay? There is a difference, but you use foreign trade zones to produce a product and take advantage of the duties. So you bring in oil as a crude oil to the foreign trade zone, and you break it down into the petrol, the benzene, and the other petrochemical materials such as lube, such as grease, such as materials which are used to produce polyester, for example. But you do not pay duty on polyester, grease, benzene, or petrol. You pay duty on oil as brought in, which presumably is either low duty or duty free. Okay, and you do manipulation of foreign trade zone, but you pay on the good which is brought in. So that's one way. Okay, another way. So you bring the whole thing and you break it out. Another way is you bring the parts and you make a whole thing. So you, for example, it costs you more to assemble a car, right? To import the car together. So you bring in parts and you assemble the whole car, but you only pay duty on parts, not on the car. Okay, if that is to your advantage. Here in New Jersey we have, for example, pharmaceutical companies which bring vitamins in bulk, in big blocks, right? And then they break it out and put it in the tablets, right? They pay on the bulk, not on the small tablet pills. Like you saw from earlier examples, there is a difference if you bring 10 kilograms as opposed to bulk, right? So this is type of difference that can be meaningful if you are if you run the processing operation or manufacturing plant or the refinery plant. So you may want to consider entering the merchandise into the free trade zone before bringing it into the United States commerce, or United States commerce. So what you do is you make a foreign trade zone entry, which is type 6. Okay? We'll have a separate discussion on foreign trade zone if time allows. But basically this is the idea. Quota visa and ADD CVD combination. By now you should know that AD stands for anti-dumping duty, CV stands for countervailing D duty, okay? And you may have a combination of that, which is harsh, but it is possible, and if that's the case, use type 7 entry. Duty deferral. How many people here have duty deferral? All right, we have one. I have a colleague who is a NAFTA specialist, and she deals with that all the time. If stuff like that comes across my table, I usually push it over to her. What it does is, if you bring something in, let's say you bring, well, I don't know, you bring unassembled paper stapler, right, to United States, and you bring in parts, so but you don't want to pay duty on parts, because once you assemble it, it will be cheaper. However, you can only take advantage of that if you're going to sell it in, for example, Canada or United States. So what you do is you make the duty deferral type 8 entry, bring it into the United States, but you pay the duty only on exported, when you export it, so you defer it to Canada or Mexico, presumably at the lower cost. That's the reason why you got the duty deferral in the first place. So it's almost like FTZ concept, except it pertains to NAFTA. Informal entries, and most of the things I haven't seen too many questions about duty deferral, and those ones that I've seen is stuff like, is duty deferral type 8 entry? Okay, and you know, by going to block 2, you should know that if you're dealing with the entry type, you need to figure it out. You go to block 2, you don't go anywhere else. Informal entries we talked about, there is free and dutiable. If it's it can be duty free, it doesn't mean you can avoid, for example, other fees such as harmonized processing fee and manufacturing processing fee, which we'll talk about later. Quota and other textiles. So even if it's informal, it can be subject to quota. But if it's a textile, it should be under 11. Okay. Warehouse entry. We talked about warehouse. Warehouse is when you shift between the warehouses from one warehouse to another. Temporary importation under bond is when you bring stuff in under bond, meaning that you pay deposit to customs, you bring it in temporarily, usually within, I think, for a period 1 year, but you can extend it. And this is for temporary use, such as machinery use or for trade show, for example. See, there is the next one, trade fair. Permanent exhibition, museum, foreign trade zone admission. Of course, once you bring it in a warehouse, you have to withdraw it. You can only bring it to the bonded warehouse for 5 years. Okay, this is a time limit. After 5 years, you must withdraw it from the warehouse. And when you make a warehouse withdrawal from the bonded warehouse, you either do it for consumption, and if it's subject to quota visa, such as food products, agricultural products, there is a separate number for that, dumping, and combination of dumping and visa. So there you are. So you have those, you can see the pattern, you have the variations which repeat themselves, as whether it's a remember, we started off with the essentials, where you have consumption in formal warehouse, and within consumption in formal warehouse, you have all those variations. And government we talked about. Keep in mind, if it's a contractor, it is not government, even though it's doing stuff, doing things under the government contract. Yes, Sunny.
Did the government shipments or entries, did they need to sign a power of attorney? Just curious.
Yeah, we had a question like that, right? Where
in the examination? Yeah,
remember we had the exam question where it was suggested that customs needs to sign a power. If it's Customs and Border Protection makes an import, it doesn't need a power of attorney, and the question was false. Of course, it depends on the context, right? So theoretically, you have a rule within the Code of Federal Regulations saying that before transacting customs business on behalf of another, you need a power of attorney. So in this concept, yes. But you have to look at the facts. Generally speaking, yes. Anytime you transact, the general rule is anytime you transact custom business on behalf of someone else, including the government, you have to have a power of attorney.
Who will sign the
Government agency. Yeah, government agency. So, or representative of government agency, of course. It's who is authorized to do that. Transportation. If you're only using United States as a transit zone, or using part of the United States, such as an immediate transportation. Remember Florida, Minneapolis example, Miami, Minneapolis. You using the route between Florida and Minneapolis as a transit zone, and you make an entry in Minneapolis. Transportation, exportation, you bring stuff in Los Angeles for the maquiladora in Mexico. And immediate exportation, you brought stuff into one port, and without even bringing it into the territory, you export it immediately. So, for example, you had the merchandise such as rugs. Rugs were found to be infested with some kind of rodents. USDA did not allow the import. You didn't file the entry yet. So what you do is you file an entry for immediate exportation. Okay. So those are the things that I wanted to talk about as far as entry is concerned. Let me see. I also have some questions. So, for example, the block 2 questions. So, here's a typical question that customs examiners might ask. Customs business includes all of the following activities involving transaction with U.S. Customs and Border Protection, except, okay, so payment of anti-dumping duties, that's customs business. Department of Commerce, see, calculated by the Department of Commerce. Here you see the DOC. You, as a customs broker, you are responsible for assisting in figuring out the amount of duties. And to clarify your earlier comment, Andrea, so you have a regular duty, right? Regular. Then you have ADD, if you do. Then you have CVD, and you all add it up, and you get your total. That's how you break it out, usually on the entry summary. Submitting an importer security filing. That's the right answer. But the reason I highlighted this is to make a point that you have to eliminate this, or to answer this, you have to know what type 1 entry and type 3 entry is, right? And we just talked about. So this is, so they're not testing you directly on it, but to answer this, you have to know what are they actually talking about. And we just talked about the block codes, right? Type 1 is a consumption entry, regular consumption entry. Type 3 is an anti-dumping duty entry. Okay, makes sense? Any questions? Can I move on? How many people are not customs business? 111.1 19 CFR defines the customs business. Anything related to the import-export clearance process. We did not talk about this yet. Actually, we did. I think someone asked me a question whether this constitutes a customs business, and I said no, because it can be done by the vessel operating common carriers, by the forwarders. Yeah, and they do not have to have a license. And because they can do that, they have a special exception carved out in the regulation. Almost like doing a post-entry, like a protest. Protest is also not customs business because they have a special rule carved out for them. But to answer this, from type 1 to type 3, you have to amend the 7501, the entry summary. And you are doing the form amendment. And because you are doing form amendment, it's part of customs business. Okay? All right. Let's see. Here's another one. A domestic express consignment operator that is also licensed customs brokerage named Quick Logistics. I think you guys seen that. I assigned it to you already. Acted as an importer of record in order to expedite U.S. client entry of equipment at this and this time. So in February, Quick Logistics had a new customer, this corporation, which is domestic and surgical. Which statement is correct? Look it down. Answer E. A warehouse entry of surgical equipment is classified as entry type code 1 on CBP Form 7501 entry summary. You know immediately that this is incorrect because warehouse entries are type 2 entries. Here. Warehouse type 2 entry. Yeah. So this is how you're being tested. Is you're just being thrown a bunch of answers. It's incorrect answers, or possibly as correct answers. But to eliminate them, you have to know this. Sorry? Oh, you want to see the question? What time is it? It's almost 1 o'clock. Do you guys want to take a break? Oh, you want to see the question? Okay. You want to know the answer, right? A domestic express consignment operator that is also a licensed customs broker named Quick Logistics LLC acted as an importer of record to expedite U.S. client medical house of surgical equipment. Quick Logistics LLC had a new customer, a cut above corp, also a domestic surgical source, so it's a domestic company. Which statement is correct? Express consignment operator that is also licensed customs brokerage may not act as an importer of record. So this is not the answer you're looking for. Why? Because we know customs brokers can be importers of record, right? Okay, next. Due to health concerns, you don't need to read this far. You need more information. You have quarantine. You have known. We had a swine flu outbreak, and we know CDC, Center for Disease Control and Prevention, they can impose a ban on certain imports. So we had a ban on swine from certain swine products from certain areas of People's Republic of China. Yes, but you do not have that in answer pattern. I mean in the fact pattern. So we know Quick Logistics must disclose its importation of medical or surgical equipment prior to engaging customs business on behalf of cut above Rest Corp. Is that true? When you must disclose? Only if you are a customs broker doing it for yourself, or you are an employee of customs broker doing it for yourself. So that's false. Medical equipment may be classified in Chapter 4 of the Harmonized Tariff Schedule of the United States.
answer E, yes. I think the C is the true number.
Oh. Okay, here is the thing, guys. They didn't. Here is the thing. Ha! Look. They acted as the importer of record.
Right.
So it means they imported on their behalf, and that kicks in the conflict of interest. They didn't only act on behalf of the client, but they also took responsibility upon themselves. So it's like they bought it. They assumed legal responsibility. And because they assumed legal responsibility, then they must disclose, because there is a conflict of interest provision. If they were doing business as a licensed custom broker, and Quick Logistics does not have to be importer of record, they can be just a broker, then that would be false. And this is something I oversee. So again, attention to details is the key. I actually brought it for the different reason. I brought it just to show you the E, how you've been tested. But you guys are very good. You got me. 2 times. Okay, let's take a look at another one. What type of entry code is a duty deferral? Okay, at least you know where to look. This is a duty deferral one. It's type 8. Okay. What is the another question? What is the correct entry summary type for the warehouse entry of TAB?
Oh, let me tell you right now. 23.
Yeah. The point of this is a quick, easy question. They should take you like
2 seconds.
Well, 10 seconds, okay? But they should not take you 3 minutes like you're supposed to. So, and it would be a pity if you guys do not know where to look, because this is just a giveaway. All you need to do is check. So, this is the key, and you just need to know where to look at. Block 2, CBP 7501, instructions. Okay, and CVD ADD combination. So it's first of all, it's a warehouse, quota visa, and ADD CVD. So it would be maybe this one, maybe this one. I'm not sure, but I know it because it's a. Wait. Hold on. So warehouse withdrawal.
32.
38. Yeah. You really have to look, so you cannot go off the memory. I just made the point by marking the wrong answers. So that's block 2. Where did we stop? We stopped at the block 2. We were going to the block 3. Okay, take a marker out, please, and do me a favor. I've seen this tested before. This sentence, highlight, please. They may just ask you this in true or false questions. It says a live entry is when the entry summary documentation is filed at the time of entry with estimated duties. Okay, highlight this, and when you review this, please pay attention to that, because this implies that you should know what is not a live entry. Because live entry, you must have entry summary documentation, which is 7501, entry summary, and duties, right? We all know that sometimes you do not file entry summary, you file entry, like form 3461, and then pay duties later. Wait 10 days, and then file 7501. Okay, that's not live entry when you're at this step. At this step, it's live. Okay, so just highlight this. I've seen it tested, and make sure when you review this, because you will be, you know what I will do. I will ask you to review this on a regular basis. This is what you will need to do. Hopefully it will catch your eye. Okay, next. Block 3. Block 3 covers the summary date. Okay, it covers the date on which entry summary is filed. One thing I must point out is that entry summary date is not necessarily the entry date, because we can have entry summary which is different from the entry date, or for that matter from the date of import. I don't have much to say about this one within itself. I haven't seen many questions with respect to that. Just know that entry summary date is not necessarily the import date or the date of entry. Okay, next, surety number. Surety number is the topic which I will cover in more detail later. We came across this already. Surety number is that insurance company which approves your bond. Once your bond is approved, that means that you will have certain number. The company that is acting as surety, it cannot just start its business. It must apply with the Treasury Department. And Treasury Department, once it approves, it gives a certain number. And once you make a contract and purchase a surety bond, then that is a number that you put in block 4. That's all what it says. And when do you not need? When you can leave it blank? Anyone? When do you not need a surety?
Informal.
Informal entry. Yeah, so you can leave it blank if you're doing informal. And 7501 can be used for informal entries. Correct? Okay, however, if you are required to file a surety, you must differentiate between the bond. So entry types not requiring the bond, so this will be like informal. But there is also type 8 and type 9. We will be covering the difference, but for now note that continuous entry bond is when you import multiple transactions. Usually the threshold amount is $50,000. So if it's $50,000 or more, usually continuous bond is required to be filed. If it's a single transaction, $50,000 or less, then you can file a single transaction. Okay? There is a whole directive which we will cover. It's a piece of paper like that, except it's all about bonds. We'll go into detail. For now, just know that you would be dealing as a customs broker with two types of bonds. So when you have an importer, you will have to ask, okay, what kind of bond would you like, continuous or single? And when they ask, what's the difference? Well, for now, know that the difference is in numbers, number 8 versus number 9. But you also know that continuous is for multiple transactions spanning over a period of time versus one-shot deal. And then there is this $50,000 threshold. Next. Single bond, I'm sorry, ma'am? So, oh, you're talking about the minimum charge. The minimum charge usually refers to, so I remember there was a minimum charge, but I'm not talking about the informal. Informal entry is the entry when you have a $2,000 threshold. If you have informal, you do not need to be bonded unless it's a special type of merchandise. I believe if it's an anti-dumping bond is required, and I believe it's textiles bond is required. We're not talking about exceptions. $100 charge, I believe, refers to the payment for the bond, right? That I believe is in the outline. Unfortunately, I do not remember if it's required or not at this time. Sorry. I will make a note and I will get back to you though. $100 charge. Okay. Let's move on. Port code. Does everyone know where to find the port code?
Yeah.
Annex C of the harmonized tariff schedule. It's in the back. It's usually 4-digit port code. What's the port code for New York?
1001.
Okay, and you needed to know that, right? What about New Jersey? 4601.
Right?
Don't worry about writing it. You will have to look it up anyway. So, the point of the port codes is you have to know where to find them. That's all. Next, entry date. Okay, entry date is not necessarily the summary date. Okay, it's the date on which the goods are released. And then there is exception, of course. There is a immediate delivery, IT. There is a quota, and the filer requests another date of release, which is a possibility. But general rule, when the goods are released, this is a date of entry. This is a default rule.
So when you do the immediate delivery, what's the entry date?
Immediate delivery is it comes in Miami for Minneapolis. The entry date is when it enters Minneapolis.
Okay.
The import date is when it enters Miami. Okay, so that is the difference, because when it's under the immediate delivery, the goods are not released. You cannot take them out. You can transport them, but you cannot take them and sell them on the site.
Until it's to the destination, that's the entry date.
Yes, it goes in, but then you have to you file documents too in Minneapolis, for example. Until you file the documents, the goods are not entered.
Do you mean this release is withdrawal from the warehouse, or?
If you make a withdrawal from warehouse, the entry date is the day you make an entry for the withdrawal. You file 7501. Once customs approves it, usually they give you notice. If you do it electronically, they send you the message back saying released. That's your entry date when you got that message.
Is this
See-
the same meaning of the withdrawal from the warehouse?
Same thing, yes.
Oh, okay.
Yes. The problem with immediate delivery is when you bring things in, many people may be thrown off because it's inside the country. It's moving from Florida, let's say, from Miami to Minneapolis on a rail. It is very easy to get into the mindset that yes, since they are moving inside the country, they are kind of released, right, from port of Miami to the port of Minneapolis. But at the same time, no. They are released only to get from point A to point B, so they can get cleared in Minneapolis. So this is important. They've been approved for transportation, and that's okay. I think I just said something wrong. Immediate delivery is not necessarily IT. I'm confusing with it. Immediate delivery is when you have perishables, like strawberries, okay? which cannot wait in the heat of the Mexican border and must go directly to the warehouse for to be cooled. Okay, and once they're in the warehouse, you have to wait for customs to release them. This is the concept which we'll talk about later. The general rule is when they're released. Immediate delivery is not when they're released. I have strawberries, I have blueberries. I cannot wait for them to rot in the sun. I have to bring them into the warehouse in a cool place. And once they're in the warehouse in a cool place, I have time to fill out the paperwork. I have time to maybe sort out bad strawberries from the good strawberries. And I have time to have inspector come in and make the approval if they want to examine. That's immediate delivery. I immediately deliver them to the warehouse. It's possible to do for the special types of merchandise. Okay, and again, we shall talk. This is introduction to the entry, so we shall talk about this in more detail later. But this is a general rule. Entry date is when it's released. And why is it important? Because entry date usually drives the duty rate. The duty rate is determined on the date of entry. Of course, there are exceptions, but that's a general rule. Okay, importing carrier is next. What should we know about importing carrier? Here is a question that has been asked before. Get a highlighter and underline this. The reporting of vessel flag is not required. This was asked a number of years ago. Again, it's in statistical note 1, but who remembers that? We have so much information to remember. It's just an extra piece. And I think it's one of those true or false questions. Which one is false? Is reporting of the vessel flag required? No, it is not. However, IATA alpha code corresponding to the name of airline is required. Each airline has its own identification code. I believe IATA stands for International Air Traffic something. I'm not sure, but it pertains to airplanes. So I guess what customs examiners are testing you on is that they're testing your knowledge land versus sea. If it's a sea, then the vessel flag is not required. But if it's air, you have to disclose more information such as IATA code. Okay?
So do we have the IATA code in the HTS? No, right?
The IATA code in HTS, no, you will have it in bill of lading.
Oh.
So you will get
So they will not
airway
test-
bill,
test
airway
it.
bill, I'm sorry.
They will not test us.
They did test before on whether reporting vessel flag is required or not. But conversely, they can test you on that. On this one, I think if they test on this is ripe for questioning. So know that vessel, if it's a sea vessel, ocean carrier, the flag is not required. The IATA code for if it's air vessel, airplane, it is required. That's the way I would just make a mental note in my head. And so yeah, this is all I wanted to say about the block 8 of 7501. There's other information, but haven't seen it tested much. Now, next one is a mode of transport. So each mode of transport has a code. Remember we discussed in block 2 the entry type code. So if it's warehouse entry, it's type 2. If it's consumption, it's type 1. If it's anti-dumping, it's type 3. Well, if it comes in by certain type of mode of transportation, you also must assign a code. And the way you may be tested on is just like you can be tested on entry type. You'll be given an invoice, and you'll be given some kind of vessel, blah blah blah, and then you'll be asked to pick the answer. and one of the answers will have type 11. And they will say something, which one is false or which one is true. Okay, this is typical exam approach. So know that the block 9 contains your answers, and most heavily tested are type 11. So what I would do is I would make myself a note. Just review type 11 is vessel container, international shipping container. Those things that we see on the road all the time, which look perforated. Next one is rail container. Then there is truck, usually for NAFTA or Canadian shipments, non-container and container. And then highlight also 40, air non-container and air container. Okay, those are, if they're gonna test you, more likely those are the ones that you'll be tested on. What is 11? What is 40? You have containerized cargo. Anyone knows the difference between the air container and the vessel container? So air container looks something like this. So it can fit the fuselage of or the salon of the airplane surrounded. Okay, any questions on this? This is just stuff you need to look over frequently and memorize. Those are the easy stuff. Country of origin is more tricky. Look at what it says. It says, well, first of all, you must use International Standard Organization country code, which is Annex B. Okay, Annex B. This is where you find out that MX stands for Mexico, RU stands for Russia, United States for United States, US for United States, and so on and so forth. This is where you will find out whether stuff that come from the England should be declared as stuff that come out from Great Britain, from United Kingdom, from England, or from some other name which I cannot think of. Wales. Or this is when you know whether to declare Heineken beer as country of origin being Holland or Netherlands. Okay, this is your chart. Where is Annex B of the HTS? Everyone knows? HTS US Annex B. Here. It's way in the back here. Statistical annexes. So you have custom core codes, which is C. Right before it you have international standard country codes. If anyone curious, so how would you label England? Anyone? UK? UK or England or what? So it's GB, GB, yeah. So you're not using EG or you're not using UK, right? All right. There was a question on Great Britain. I think which repeated several times in the last 5 years. So this is where you go to look for your country code. Right? So Ireland, for example, is IE. and IR is Iran. One would think that IR would be for Ireland. No. So, very important part. Know where to find it. I don't think it will be fruitful for you to memorize all this stuff, but just know that this is a part where you go for your reference. Okay. So we're still on country of origin. We know that we need to go to the Annex B to look for the countries. We know that UK is England. And we also know that not everything sometimes is always made in one country. You can have some pieces coming from various countries and being assembled in one, and then being transformed in another, being packaged in another, being labeled in yet another country, and being, I don't know, stored in another country. All right. So what is the rule of thumb that tells you this is a country of origin? So let's say the tomato was grown in Ireland, then it was dried in Wales, then England, then it went to in England it was dried, in Denmark it was packaged and put flavoring upon, in Amsterdam, which is Netherlands, it was packaged and labeled, and then it came to Canada where it was mixed up and then imported to United States. What's the country of origin? Okay, you see a bunch of steps that it took. So what's your rule of thumb? The rule, by the way, I do not know the answer to that. I just made it up. But you will have questions, although less involving less steps. So the rule of thumb is highlight this. Actually highlight this whole thing, but underline this especially. The rule of thumb is substantial transformation. The country of origin is the country of manufacture, production, or growth of any article. Of course, by word country as singular, it presumes that one article is made in one country. If the article consists of material produced, derived, or processed in more than one foreign territory or country, foreign meaning outside of the United States, or insular possession of the United States. So if you have insular possession, which includes Marshall Islands, which includes Guam, which includes US Virgin Islands, which includes Saipan. What else is insular possession? I haven't seen Guantanamo. I think Guantanamo has a special status. But if insular possession, okay, is also considered to be the product of that country or possession, is a product of Guam, where it last underwent substantial transformation. And that's the best they can do. Customs to this day has not promulgated any regulation that says this is the meaning of substantial transformation. So it's an eye of the beholder. To make it easier, they did make some rules on case-by-case basis if this article is subject to the free trade agreement. So if you have NAFTA, you have objective criteria, you have tariff shift. If the tomatoes were changed from original fresh tomatoes to the dry tomatoes, and then went from, let's say, chapter 16 to chapter 20, they say, look, if they made the change from one chapter to another, they jumped, that's substantial transformation, that prong is met. But if it's not a textile, for textiles they also have chapter shift. If you jump from one chapter to another, or from one subheading to another subheading, this is how you determine, okay, in this country it was changed from this HTS to this HTS. In that country it was made to change to this HTS to this. That means it qualifies for origin. If it's a textile, you can do that. If it's a free trade agreement, NAFTA or Morocco, you can do that. But if it is, for example, European Union which has no free trade agreements as such. It has general MFN, most favored nation type under WTO, but that's it. No bilaterals. So if you have something like Switzerland, which is by the way not part of the EU, or if you have something like UK, and you need to determine whether the product underwent substantial transformation from in UK from Switzerland, so you should declare it is UK, not Switzerland, then you have and this is not a textile, then you have this ambiguous substantial transformation, kind of like, yeah, it probably underwent substantial transformation. So objective for textiles and bilateral free trade agreements. Subjective, all others. Subjective meaning you just have to look at it and kind of like essential character, right? You have to try to figure it out. Customs examiners usually will give you a big clue if there was a substantial transformation by saying you started with metal and you ended up with a bicycle made out of metal, let's say. That type of stuff. So because if they're gonna stick at the subjective, where it was marginally transformed, right? This is very easily appealed. Okay. So next, don't hide your highlighters. Please make sure to. I felt like I was substantially transformed. All right. So to the country of origin. So if this is 9802, which is a special category, the country of origin should be shown as the country in which the repair, alteration, or assembly was performed. So you have a special category for chapter 98. If stuff were done, so my watch broke, okay, it is under warranty, and it is being fixed in Canada. What I do is I ship it to Canada, and then back after they fixed it, okay. It undergone repair. So when it comes back from Canada, I declare Canada. I do not, even though just a repair was done, it's the same watch. They just fixed the one screw that didn't work, for example. Okay, next. Just to drive things home, highlight this portion. The actual country of origin shall be specified rather than the country of invoice or exportation. Yeah, a lot of things happen in this world which lead many exporters and importers into a world of trouble. They transship stuff through Honduras from China, and they say nothing happened in Honduras, it was just loaded from one ship to another. It didn't even leave the container. So country, maybe it even left the container, but nothing was done to the article. Sometimes you see people saying, well, it came from Honduras, so the country of origin is Honduras. No, it's not Honduras, it's China. You have to have substantial transformation before anything else to qualify it. And substantial transformation is not mere taking things out and putting things in. There is an exception to that. I know of only one, and that's a Singapore Free Trade Agreement. I do not know how they've done it, but they went to United States Trade Representative, the government body which is responsible for free trade agreements, and they say if it's stored, if it comes to Singapore and just stored, and then leaves the Singapore to United States, then you can use Singapore free trade agreement. So I think you still label it as, for example, country of origin of China, but you apply Singapore free trade agreement to the article. I do not know of any other, so very unlikely that they will ask you about it, but just keep in mind Singapore has a special rule. I think Singapore Integrated Initiative, something like that, it is called. If you like, I have an article, I can send it to you, but you probably have so much information to deal with, you may not want to read it. Now, let's see. If more than one country of origin, mark it as multi, many. And then, at each level, so this is a 7501. So let's say you have country of origin, let's see. So you have country of origin here. Oops, again I did it again. I don't want to do that. Okay. Country of origin. So if I have more than one country, that's country of origin, I put multi here. And over here, at the line item, I say Singapore, I say UK, or I say CN for China. This is how I identify. So that would be my hint. Look here. Next. So this is a typical question, right? Customs examiners, they give you this type of invoice, and they say, okay, look at the invoice and answer the following question. The question is this: the international standard ISO country code identified at block 10 of CBP Form 75.1 is which one? And they give you this information. By the way, this is a snippet of the country. Which one? How do you know which country it is? This is all you have. Usually, you remember, you put the country. They're not giving you the country of origin. You may put the country of origin here, right? You know AGOA. AGOA stands for African Growth Opportunity Act. So it must be Africa, right? We have Libya. LY stands for Libya. We have Ethiopia. Then this is Germany, United States. Well, it's possible United States, but not likely. I don't know what EG stands for. What is EG?
EG is Egypt.
Oh, so those are possibilities, right? We have Libya, Ethiopia, Egypt, right? That's the question. What's the country of origin? Okay. Go to page 19 of your CBP 7501. We'll go back to A. We're gonna fast forward a little bit. Okay. And take a look. Highlight. Take a highlighter and say this: the second and third positions represent the ISO country of origin code. The second and third positions, this is a visa. Remember we talked about visas? You get a visa, so with visa, like just like if you get a visa on your passport, there comes a visa number, right? This visa number must be reported to customs. But that visa itself is not an arbitrary number. So what customs is expecting you to do when you show up at the exam is you must know what this number represents. And one of the things they test you on it is they give you the visa number and ask you what's the country of origin. So let's go back. This is a visa number right here. I don't know if I can make it bigger and just fuzzier, but that's it. That's the visa number. Second and third position here, it's not second and third, here it's rather, oh, second and third, yes, because V stands for visa, so it doesn't count. This is second, this is third, so it's ET. This is the answer they're looking for. This is how you know from the invoice what the country of origin is. See, they're being tricky with you, right?
Where could you see the ET? I mean, I still don't.
Okay, let me make it a little bit bigger if I can.
Oh, see it. I got it.
V3 ET 022805. ET stands for Ethiopia. If it was Libya, it would be V3LY. Okay? So, indirectly, you think that they are testing you on country of origin, ISO. In fact, they are testing your knowledge on your ability to decipher visa enumeration process. See? Okay, any questions at this point? It's one of the things you just have to know. And there is no logic, but if they decided it should be last 4 digits, I would have no way for you to reason that they decided to do that. They just did. So this is the way they do it. Just keep that in mind. Okay, next. Next. So I fasted forward to page 19, which deals with visa number, but we're still on block. Okay, we're still on block 10, country of origin. This is the relationship between block 10 and block what is it? The block 32. Block 32. Okay, so that's all what I wanted to say about the country of origin. Any questions before we move on to the other blocks? So substantial transformation, know that it can be objective if it pertains to textiles or FTAs, but subjective, case-by-case inquiry if it is other. Okay, Canada. Keep in mind, when you declare Canada, as your country of origin, you do not say CA. You use the province. And province codes I used to have a location for the see, they have a link for the Canadian. I think they are in the same schedule. See, let me click on it. No, they didn't tell you. Okay, the Canadian province code are listed, I believe, in let me see. Okay, so they right there. Okay, guys, I'll send you the separate email for Canadian province codes. Just a moment. What I wanted for you to get out is country of origin. You declare Alberta or BC, British Columbia, right? But if you're talking about not the block, let me see, CBP 7501. If you're not talking about the block country of origin, here you declare the province. But if you're talking about the HTS free trade agreement, such as NAFTA, like CA or MX, right? You still use CA here at this level, because this level, it's called SPI, Special Product Indicator, will allow you to claim the preferential duty. So here you say BC, British Columbia. Here you say CA, and you use the HTS US number. Okay, that's the point of filling this one out. Or same thing goes to Mexico, Jalisco, right? What is it? Jalisco, HL. Here it's MX. Guadalajara. No, it's a city. My favorite is Yucatan. Okay, any questions? May, have a question?
Just like you said, CA can use animal use, cannot be organisms.
What page are you on? Page
This one.
6? Okay, just a moment, let's be in it together. So, ISO country code CA for Canadian goods of Canadian origin no longer will be reported as a country of origin, the top box. Okay. Since 1997, the Canadian province codes replace CA. However, it's a general rule, right? And we all know that where there is a general rule, there is also exceptions. And the exceptions are the following. You have 5 of them. 6 exceptions. If you withdraw it from the warehouse to consumption, use CA. But why am I not making big deal out of it? Acceptable means not required. So you will not get rejection, you may have an angry customs official who's calling you saying that you're not complying with the local port practice. If you're a soft person, you may be upset about it, but hey, it's acceptable. So if it's not required, then I'm not make it a hard point drive that saying that you must. But CA is acceptable if it's warehouse, FTZ, informal, imports of Canadian origin arriving from countries other than Canada. That is possible, right? With a substantial transformation. Canadian stuff came to Mexico. Nothing happened in Mexico. They were just labeled. So suits were labeled in Mexico, came to United States, country of origin Canada. Label doesn't transform the suit, right? And we have other stuff which I don't want to pollute our brain with, but yeah, we have FDA, DOT, EPA, and cargo selectivity. You guys wanna talk about it? Okay. Import date. So remember I mentioned that stuff comes into the Miami, gets on a intermodal, IT immediate transportation, and then goes to Minneapolis. Well, the import date, you put the date of Miami, of arrival to Miami, not date of arrival to Minneapolis. That's pretty much what it says. Also, what has been tested on? So grab a highlighter and highlight this. Arrived within the limits of the US port with intent to unload. Import date, so mere arrival, so you have a ship which is at the port, container is still on the ship, it didn't hit the land yet, it didn't hit the port, still in the waters, can still be considered the import date. That's the key for you to think about. And this is a type of flexibility that is allowed within the US Customs practice, because import date, remember when we're talking about import date, unless otherwise requested, I think the date of entry, okay? So that flexibility, you have a variation. Usually when you submit the entry summary, and the port must be within the shipment must be within the US port limits for you to submit the documentation. You get a notice of release before even the merchandise hit the land. Okay, that would be the import date, and that would be the release date. Even the merchandise didn't come on the land. Okay, so this is kind of like, it doesn't have to be physical; it can be constructive too. That's the main point of this. And the way customs may ask you on this is, the merchandise arrived within the port limits. Can a customs broker file an entry? Yes, because technically the input it's already hit the border. Okay, technically. Now that's not to say it's applicable for the trucks. If you are waiting in a line to enter the Mexico, and the line is long, as we know, because of the bottlenecks, you cannot do that with the truck. You have to actually hit the border. With ships, you just need to be within the US port. Okay, so that's the main point I wanted to point out. Any questions on this before I move on? Okay, so most of the documents you will be dealing with is with the bill of lading. Is you either part of the entry package. You have to have entry documents, right? Customs documents, the one that we're talking about right now, 7501. We also have commercial invoice. We have a packing list. And we have evidence of right to make an entry. It's cryptically called, but what it refers to either bill of lading or airway bill. Bill of lading usually refers to the sea. Airway bill refers to the air. And remember, the flag was not required for the vessel flag is not required to be reported for the for the C. SCAC, standard area code, you have to have it reported. SCAC is usually issued to, it is not a vessel identifier, it is rather the carrier identifier. So SCAC would be MCSU HANG. So this is Hanjin. This is I think Maersk, something like that. It's usually 4 digits. Mediterranean shipping company, something like that. So those are the ones that come off top of my head. There are many more, but that's CAC. So next is a more important one. MIT code. MIT, manufacturer identification number. So whenever you import, if you guys ever brought apples or veggies or whatever from overseas, usually you have customs officers telling you, oh, you cannot bring fresh foods and vegetables. This is not required. If you have that apple, you should throw it away. Okay? Well, that's not really true. You can bring apples, but before you bring an apple, first of all, you must know the place where it was grown. Second of all, the place that it was grown must be registered with the FDA. Then it must file prior notice. To file a prior notice, it must have US agent in place. And if in addition, if it may have sanitary certificates or any other approvals that may be required from the other agencies. You see, for one apple, you know what, I'm throwing this away. If they're not telling you this because they just don't want to bother, but technically, if I file a prior notice with Food and Drug Administration, and you can do that online, it's you don't have to have certain system. You just go to the food facility registration. It's a now unified system. You just file one apple, and you just say a flight number. Let's say you're flying from Moscow to JFK, right? You type in the file number, you type the air carrier, the IATA, you know, and alas, you have all the documents. Customs will love you for that. But you complied with the rules. There is no reason for you to throw that wonderful apple, which is probably organic and not genetically modified, right? So, but here is the point. The point is MIT code. Every time you make an entry, unless it's, I think it's section 321 informal, you have to identify the producer. You have to identify who made it and where it was made. And that can be tough, that can be tricky, because sometimes you have vendors who do not want to disclose their source. So what they do is they say, okay, I am a trader, okay, I buy stuff from everywhere, so let me put my name. Take the highlighter and highlight this sentence. Just this portion. For textile shipments, the manufacturer should be construed to refer to the actual manufacturer. What does this mean? When you identify, when you construct the manufacturer identification code, and it's a textile shipment, like let's say Flora, that suit that you talk about, let's say we bring it in, and let's say you are the vendor in Hong Kong, but the people who made it, they're in People's Republic of China. You selling it to me. I'm I don't know, Marshalls. Okay, so I'm a Marshalls bar. I come to you and I say, I want to buy that suit from you. It's a suit, it's not an assemble. So I declare only one HTS. With that one HTS, I want to point out the factory. Can I say you are the manufacturer and the mid code. No. You have to give me the name of the factory that made the suit. But let's say it is Sunny. Let's say you also in Hong Kong, but instead of dealing with textiles, you deal with toothbrushes. Now, you deal with toothbrushes. This is not textile article, and you don't want to disclose who your suppliers are. So you say, you tell me, you want to put your own name, and your mid code, manufacturer ID code, will be identifying you, not the People's Republic of China. Okay, makes sense? Okay. So basically it says non-textile shipments may use invoicing party or parties other than direct suppliers. So if the party is on the invoice, this is doable. Also, if your highlighter didn't dry out, highlight this. The name and address of the invoicing party whose invoice accompanies CBP entry should be used to construct mid code, subject to this exception. This is exception, okay? The manufacturer is required the manufacturer shipper identification code is required for all entry summaries. So if you have many manufacturers, you have factory 1, 2, 3, you have many mid codes, presumably. What you do is you just like with the country version, you put multi. Just to make sure we are on the same page. This is the mid code, you put multi, and at each line item you put a mid code here, mid, etc. That's what that explanation tried to say. So now, any questions at this point? Anything about mids? Manufacturer idea. How about, I have a good question, I guess, for myself. How do you make the mid code? How do you construct the mid code? Appendix 2. Where is Appendix 2? It's all the way to the back. So flip to page 30 of your handout. And remember, I promised you to ship it, to send you the codes for the Canada. Well, I take my promise away from you because you guys have it on page 30. And British Columbia was not BC, it's actually XC. So this appendix 2, tells you the rules of construction, and customs examiners had in the past tested you on how to construct the mid code. Usually, once you pass the customs broker examination, you will forget about it and you will never get back to it because computers do it for you. This is simple information. I had one time when I had to deviate from the computer because the shipment which I constructed using the computer system, the mid code for that manufacturer coincided with the mid code of the party which was under sanctions, and the freight was seized automatically. And when I started speaking with the officer, with the investigation officer, he said that this shipment has been seized because even though you point out the different manufacturer, that meat code has been associated with a sanctioned party, and as a matter of law, we are required to seize it. I said, well, what can I do to get it out? Well, he said, look, you gave me all the evidence, so this is I buy it. Okay, this is not the guy, but in the system you have to go and change the meat code, because I will look bad. Because when the audit comes in, they will say, oh, what's going on? You guys let go of the sanctioned parties, come make entries into the United States. No. So I had to manually deviate from the procedure. Okay, he actually told me what I should use, not to be in trouble. But yes, that's an exception. You will not be tested on that, but you may be tested on how to construct a meat code, and it's pretty simple. You just have to go through it once or twice, and you'll know it. You'll know what to do. Here are the key points. First point, first two characters use ISO code. So in the meat code, you have first two characters will be the country of origin for that country. So it's France, FR, right? If it's England, it's going to be UK. Those will be first two. The meat code will begin with those first two numbers. Next, take a highlighter and highlight this sentence. First three characters of the first two words of the name. So let's say this is Smiley's yarn. Smiley's yarn. You take first three characters of the first two words, and let's say Smiley's yarn is in the United States. It is in fact in Jamaica. They sell yarn, so if anyone likes to knit, it's a cool place to go. Better than what is called Michaels and all that stuff. So for Smiley's yarn, I would say US because it's in US and it's in Jamaica, New York. Then I put SMI, first three characters, and then YAR, right? Smiley's yarn. So next, anyone gonna ask me why, how I know the Smiley's yarn stuff, the way that I like to knit? No, it's my wife is a big time knitter, so and she doesn't drive, so I drive her over there all the time. And thank God I got one of those smartphones, so now when she's there, it's the most boring part of the day for me. I just stream some stuff. I stream like videos or maybe read books. So that has been a saver for me. Anyway, let's next. If the manufacturer name ignore English words A and N, so it was Smiley's and yarn. Okay, you just ignore it. So highlight this portion. Okay. Then highlight name separated by hyphen are to be treated as a single word. So it was Smiley's hyphen yarn. Then I would only use SMI, no YAR. That would be an example. So note that some names will include numbers. 20th Century Fox as an example. You use the numbers. Okay. Notice first three. Con 200. So that's it. That's pretty much, you almost done. The next thing you need to do is, I'll get back to the skip portion in a second, but this is number, so let me mark it up. So on the sidelines, right. To begin with, this is step 1. Okay? Next. This is step 2. This is step 3. Okay, so the step 3 is find the largest number on the street address and use up to 4 numbers. So up to 4, if it's less than 4, use less than 4. If it's up to 4, so you have 11455 Main Street, you would say 11445. So if that Smiley's yarn was USSMI yarn, and it's located, I think, like 2005 Jamaica Avenue. I'm not sure if that's the correct address, but what I will do is I will use up to 4, so 205, like that. Okay? So pretty simple, pretty straightforward stuff. You just need to remember the process. Keep in mind, if it's sometimes it's written 1000th Century Plaza, okay, then don't use it. If it's written out, don't worry about numbers, forget about them. And the step 4 is here. It's the very last step you need to do, so there are 4 steps. Use the first 3 alpha characters in the city name. So the city name would be here, New York. So should I use Queens, or should we be using Queens or New York? I think it would be New York, because it's under New York City. Queens is just a borough, so it would be New. There you go, I just made a mid code for my wife's favorite knitting store. There you go. Okay, any questions? How about exceptions? How about things like this? So this is exceptions. Macau. And of course, customs loves to test you on exceptions, especially when it comes to min code, because stuff is so straightforward that it's kind of boring. Okay, so they're gonna ask you on exceptions, which we shall see in a second. So Macau starts with the same words as Fábrica de artigos de vestuário. Okay, which means factory of clothing. If you see that, then avoid it. Ignore it. Fábrica de artigos de vestuário. If you have Indonesia, if you see PT, avoid it. If you have Russia, if you see those symbols, avoid them. I'm not sure about Indonesia. I see many PT. I see many PTs, PT invoices in Indonesia, but for Russia, I can tell you this. This stands for OAO, Open Shareholding Society. It's equivalent to Inc. It's equivalent to publicly listed corporate entity. Except in the United States we put Inc. at the end. In Russia they put OAO at the front. Okay, this is non-public corporation, and those, I think this is joint venture, and I think this stands for some kind of organization. I'm not sure. But in Russia it is customary to put them before, and since many of them start, it would be hard to identify the name because many of them start with that. And here are some examples. Anyone would like to volunteer and I tell me where FR comes from? Let me make it a little bigger. How about that? So FR comes from what? France, right? LAV. LAV, so first three here and first three here. LAVE, right? Then comes up to 4 digits for the numeric digital code, right? You have only 3 here, so that's why you use only 3. And Bremont is the name of the city. You use 3 characters, which is here. Make sense? Country, city, name, and the street address. Make sense? Okay, next. Next. 20th century technologies. So this is Venezuela. VE comes from what? From country, Venezuela, right? 20 comes from the name. You use 20 and then you use first 3. If it was 201, 201st century technologies, it would be 201. But here we only have 2 and we have 3. Again, 2, 3. Sorry. See, look, point, look, check this out, guys. They're taking the T, yes. So if they put it up, if they put the uppercase or the lowercase, it still counts. So this is a good example to make a note of. Of course, you have 508. Notice it's not this one, but you start with a suite. And you go up to 4 digits. And Caracas, first 3 letters of the city. So the main point here is not to disregard the uppercase T, 20th. Next. The UK E.K. Rogers Company from London, England. So, as we know, wait a minute, wasn't it, didn't you say it's UK?
Yes.
How come they're putting GB?
Oh, that's true.
Okay, hold on a second. So,
What GB is.
so is it UK or GB? ISO code, England. A, B, C, D. So there is,
GB is United Kingdom, though.
Yeah.
United Kingdom is the word, but
yeah,
GB
but
is the
Great Britain
abbreviation.
is Great Britain is not listed. Look,
No, it's under.
Great Britain is not listed. The England is not listed either.
It's UK.
See, you have, if England was listed, it would be after Equatorial Guinea and before Eritrea. And Great Britain it's not also not listed. So United, you have only one thing left, United Kingdom, right?
Yeah.
And here it is, GB. I think I even have it selected. Okay. So everyone, when you think of England, think of GB. Great Britain. So you start with a two-letter country code. And then you remember, you avoid abbreviations, right? The, and, remember, you avoid those. So this is a good example where you would avoid them. You focus on first three, here you have only two, and you first three in the second word. So you have EK, first three in the first word, first three in the second word, and then you have city name. Notice, if you had, instead of one, you had one, you would write it in here, one. But because it's written out like this, you ignore it, right? Remember we talked about this as an exception. The greenhouse, Birmingham, Alabama. To my knowledge, Alabama is still United States. The you avoid. GRE is the first three. You have no second word, so you don't worry about that. 45, because it's not spelled out but written out, you include it in. And Birmingham, first three letters of the city. Okay, next. Australia, it's AU, first three, you ignore that, and then first three, right, you have it here, 88, number, and Sydney for the name. Okay, so you guys get the sense, okay, what's going on. So let's go to the actual customs exam question and see how they are testing you on stuff like that. Okay, so here's a good one. You have an invoice. You have an invoice. PT Jakarta, no, that PT, you don't put PT, remember, you ignore that. Okay, PT Jakarta Garment Trading Company, and you have country of manufacture Macau, country of origin export Macau, Taiwan, and you have ship to name. So let's do the numbers. Where do we start on this invoice?
PT.
Well, you're talking Macau, right? The country.
Macau is a country, so you start where? You start with, is Macau a country? Where is Macau?
In Africa?
Macau next to Hong Kong.
Oh, yes, true. Okay, hold on.
Portuguese, right?
Before.
Portuguese had a colony there, trading post. I believe it was surrendered to People's Republic somewhere around Hong Kong time. Now It's a center where everyone likes to play casino. I don't know if you hear of the.
Sin City.
Yeah, yeah. Sin City? Is it Sin City? Okay. So, Sin City, China style. Right there. What do you have? So, you have Indonesian code. So, who do you declare here? How you are given this invoice? You have to do the code without even looking at the answers. What are the things you know?
Well, the manufacturer identification number.
Where?
The country of manufacture, right?
Country of manufacture is Macau, right? Okay, so okay. Let me see. So let's look at Macau. Macau is MO. Okay, so MO. Next. What do I put next?
Yeah, but Macau is not a country, right? I mean,
Okay, is Macau a country or not? Is Hong Kong a country?
No, it's a territory.
It's a territory.
Yes.
So tell me this, ladies and gentlemen.
Yeah, Macau's on
If
there.
it's listed separately, should we? Does it mean that we use MO or does it mean we use CN?
MO.
Okay. Why?
Because they are not considered part of.
No, it's a good question because I had a problem with that, especially in Hong Kong scenarios. Why can't I declare stuff out of Hong Kong as
But they are not
CN?
really made in China, Macau. I mean, they are part of the China.
When Hong Kong, I do not know about Macau, but I suspect similar thing happened. When Hong Kong sovereignty was transferred from Great Britain to the People's Republic, 1994, I believe. 97. Okay, 97. In 1994, I think back then, an agreement was made that Hong Kong will enjoy special economic status for 50 years after the transition. Because of that special economic status, Hong Kong remained an enclave within People's Republic of China as an economic market economy. Okay, market economy status. Because it has market economy status, remember I talked about anti-dumping and how non-market economy you can use, for example, surrogate like India for pencils. If a pencil is made in Hong Kong, it's not applicable because Hong Kong, if it's made in Hong Kong, it's a separate economic territory. I'm not sure about Macau. I suspect same thing happened in Macau. They have some kind of special privileged status in there, and because of that, it was within the United States government. It was acknowledged by the executive branch. There was a Federal Register publication stating that because of this special status, we are going to treat Hong Kong as a separate economic zone, almost like a same country, but for declaration purposes, we're going to say HK instead of CN. Hong Kong is not China. Okay? So when you declare stuff out of Hong Kong, there are no stuff out of China. Okay? Macau, same thing. Let's go back. So okay, why are this not Indonesia? Why we know that we need to declare Indonesia, right? So it says Indonesia right there. Why can I say I use Indonesia as a country of origin? Jakarta?
Yeah, that's
Yeah.
the city.
Jakarta is the capital of Indonesia. Okay, so
Because at the bottom it says manufacturer.
okay,
See where it was made.
okay. So, but can't you declare the trading company?
Isn't it
Could be an
clothing?
agent. It's not
Isn't
a
it a shirt?
It's adult baseball caps.
Well, that's still textiles.
That's textiles, right? Remember the special rule for textiles? You have to use the people, Flora, remember the Hong Kong example? You're in Hong Kong, but you source stuff from China. I have to do the China, People's Republic of China. Well, same thing here. These remarks are the key. I have to declare this guy. Not that guy, not that guy, but this guy. Okay? Because it's textile. If it was not textiles, I would have a conflict, okay? Because country of origin is Macau, I would put Macau, but I would most likely somehow, I would be justified to use the Indonesian guy, okay, Indonesian address. It's problematic because to make a mid code, you have to use country of origin, and the country of origin doesn't match the vendor. But the customs examiners here made it easier for you, so you don't mess up. Because they know it's very easy to make mistake, because first thing you look at is on top, not the bottom.
Right.
See, they kind of hid it from you. Almost like modern advertisement, you know, like at the bottom they say other terms and conditions, and you never read those terms and conditions. Well, this is like other remarks, other terms and conditions, okay? But those are other remarks that you are being tested on, because you know this is a textile, and it's a baseball cap. Anytime you have a textile which is within 50, from chapter 50 to 63, sorry, even before that. So check this out. This section from chapter 50, textile, section 11 to 63, here they apply, but see, headgear is here too. It is also a textile. Footwear is a textile. So this also, you have to declare the original producer. There is a directive that says all other, you can have textiles, for example, in articles of plastics. And you will have to, if it's textile article, you have to declare who made it. You have chapter 42 handbags that are made out of textile. And you have to declare the manufacturer, the original manufacturer. Articles of leather, harnesses, travel goods, handbags. It's chapter 42. But let's go back. So, okay, so now what do we use? We use, it says Fábrica de Artigos. So what do? We use FAB?
No, because it's from Macau.
Wow. You guys remember the exception, right? Remember that exception? Macau always starts with this Fábrica de Artigos de Vestuário. So this is where we start. Clothing universe. So we say CLOUNI. First three letters and first three letters of the first word, first letters on the second word. Okay. Avenida da Amizade 555. Have 555 here. I think I can use that. And how do I end it up? MAC, Macau landmark. So do I use MAC? Is that kind of like a neighborhood within Macau? Macau is like a city-state, right?
Use UNK.
MAK?
UN.
UNK? Where does UNK come from?
Unknown. He gave me a look.
It should be MACLAN.
Okay, here's the answer choice.
MAC.
Which one is correct? Mac. Which one is correct?
The first three letters from the city name. Let's go back up.
You want to go back up? Okay.
First three letters from the city name. So MAC.
MAC.
Yeah, MAC.
So MO is for Macau as far as a country, and MAC as far as a city. Do you see the difference? It's a city-state, in other words. But really, if are you really gonna go through this on the exam? I hope not. Hope not, guys. Please. Yes.
Where's
Me.
the question come from?
Yes.
Where's the question come from?
Where's what?
The question has come from.
Oh, question. I don't know. Somewhere. It comes from the exam. I don't remember where.
I know that, but I want to know.
Sorry. It's within the last 3 years it was tested. By the way, most of the stuff I don't make up. Even it looks funny, and you think this funny guy made them up. It's from customs, really. I did make stuff up for tonight's homework as far as... No, I didn't even make those up. I looked it up on the register. I give you real entry numbers and ask you to determine the check digit. So even those I'm not making... What? No, you go to the register, you show up to GFK, and they have a board, right? And they say liquidated entry because they need to publish what liquidated. And you just write stuff down, and you go and have students enjoy making up the filer codes, check digits. We'll get to check digits hopefully before we leave today. No, check digits is very easy.
Oh, it is.
It's very easy. Okay. So, mid code. So we know that it is gonna be what? It's gonna be Macau, MO, right? So we know it's not gonna be this. It's not gonna be this. It's not gonna be this.
It can't be 8 either.
Just a moment.
Yeah, she's right. FAP. It should not be there.
And we know it's not Jakarta, right?
No.
So that's it. Boom, and move on. It should take you 4 or 5 seconds.
10.
Okay, you are the U and K guy, right?
What is it? All of the
Oh,
MIT.
Unknown guy. Sunny is unknown type of guy. For you, okay, for you it should take no more than 9 seconds. But you should take less time on others, because you have to make up somewhere.
Can I get to the remarks, the bottom?
Huh? Sorry?
The invoice,
The invoice? Okay.
yeah, the remarks.
So you ignore this. This is not good. You start with Macau, MO, then CLO, UNI, 555, 555, and MAC.
So it's not use FABDE.
Do they use 555? Hold on a second. Yeah, they use. Because sometimes this is a zip code, okay? And you don't use a zip code. And this is why I hate doing the stuff at the very end, because I can never tell. In some countries, this is normal. In some countries, like in the United States, it goes usually up front. All right? Okay, so now we know something about mid codes, right? We know about the exceptions. And can we take a 5-minute break?
Yeah.
Please.
So whenever we see a remark, right, we should take on that, right?
Just a moment, I'll come back there. Page 7. Exporting country. Okay, exporting country is much more easier than the mid-code section. Generally speaking, you look at ISO country code, our favorite Annex B. And take a note. In fact, highlight this whole thing, okay? Highlight this whole paragraph. The country of exportation is the country of which the merchandise was last part of the commerce and from which the merchandise was shipped to the US without contingency or diversion. Why is this important? It is a practice in the steamship lines to have some kind of hubs. There is a huge hub in Jamaica. that hub is being used, I believe, by Hanjin, but for example, Zim steamship lines, Zim, Skakot, Zimu, it's an Israeli steamship line. So whenever they ship stuff from Haifa to United States, they make a stopover at Jamaica. Now I'm not talking about the borough of Queens, Jamaica. I'm talking about the Jamaica as an island. Because from Jamaica, things go out to United States and to Latin America. Even though that's a transaction, Jamaica is not the country of export. It would be Israel as a country of export. So this is type of situation that we're talking about. The merchandise was just transshipped from one ship to another, and or using the language of the commerce, from the mother vessel to the feeder vessel, and went on its way to the final destination. Naturally, this flows into the export date. Highlight this portion. The carrier departed the last port of exporting country. So if it went from Haifa, Israel, to Jamaica, then to Houston, the last port of the exporting country was not Kingston, Jamaica, but it was Israel, Haifa, Israel. Same thing for European bound shipments. It went from Athens to Rome to New York. The last port, given nothing happened in Rome, like it wasn't sold or changed title, the export date would be the date when it left Greece, when it left Athens, not when it left Rome, meaning European Union. Why is that important? Because, as we shall later see, the export date determines the exchange rate if the currency if foreign currency is being used.
Wait, if it left, where did the freight originate from? Greece? And
Okay,
to Rome?
so let's say Athens. So it's a normal steam ship. It landed one ship,
Right, your first port.
then it went to Athens, then to Rome, then to New York City.
Right.
Let's say it left on 1-1, then it arrived and stopped there at 1:10, which is too long. Let's say 1:4, and it came to New York City at 1:27. This will be the exchange. This is the, if you're using a Greek, they didn't leave the Eurozone, right? Yet.
On the test?
No. The Greece did not leave the Eurozone.
Oh, no,
just
I think they're still part of the Euro.
okay. So the euros, the currency conversion for euros. Let's say the invoices. Well, customs will do. They give you invoice in euros, and they give you this fact pattern. And they'll give you the dates when euro was $1 equals to 0.75 EU, and here $1 equals to 0.9 EU. Okay, you use this. Because it did not enter the commerce, even though it was part of European Union. I believe it still is. 1.4 is not the exchange rate because you use the export date. What's the export date? The date when the carrier departed the last port of the exporting country. Here the last port was Athens. This is, see how it comes together? Okay, so this is not just information in a vacuum. It has effect on exchange rates, even though it doesn't say here. Exchange rates will be covered as part of our valuation lecture. Okay, that's all I wanted to say about export date. Any questions about it? So IT date, we talked about immediate transportation before, Miami versus Minneapolis. Missing documents. So it's okay to have documents missing. Things get lost. Here is a problem though. If you report the missing documents, you may be required to post a bond. And bond for the missing invoice, it still does not relieve you from producing the commercial invoice. Let's say you lose a commercial invoice. Okay, what you will have to do is you have certain amount of time frame. I believe it's 180 days, 60 days. We'll be covering that later, but there is a time frame within which you must produce the invoice. So it doesn't get you off the hook, you just have to post a bond. And this means that you have to find an insurance company. That means that the insurance company have to increase the amount of coverage, which means you have to pay extra fee. So a lot of times when there is a missing invoice, you're gonna do the best you can not to find that invoice, or to find a reproduction copy of the invoice, but not to report.
You still need to post another bond?
Well, you're just gonna increase your amount for continuous bond. It's not, your continuous bond is not in a vacuum. Let's say you cover for 200,000, now you're gonna be covered for 250, depending on what you're missing. Yeah. Unless you have some kind of cool deal, which many people don't. Yeah. So missing documents, okay to have them, but bond may be required for those missing documents. Next, foreign port of lading. What's to know about foreign port of lading? Oh, highlight this. A waiver. If a document has been waived prior to entry summary filing or not required at the time of entry summary, it should not be recorded as missing document. What am I thinking about? Ask if it's a commercial invoice can be waived. Maybe in lieu of pro forma invoice. Ask the port director, can you call up, not a port director, but usually you call up someone acting on his behalf, such as entry specialist. You call them up and you say, hello, can I use the pro forma in lieu of actual invoice? They say yes, you got a waiver. Preferably you send an email out and get it in writing. So waiver is available. It's a discretion of the port director. Now going back to the foreign port of lading. So lading itself refers to the stuff being put on a vessel. So when foreign port of lading is where the merchandise was put on a vessel. And what you may be asked on, I believe there was 1 or 2 questions in the previous 5 years. They did ask you, where do you find foreign port of lading? Schedule K. Where is Schedule K? In the military website. Schedule K, guys. Well, this is stuff you're gonna have to fill out. So you go to the website and you put that city. Yeah. See the reason why they require a license for stuff like that? Because if you just come in and without a license and you start doing this, many mistakes can be made. So, Block 20, US port of unloading, where the stuff comes into the United States and gets offloaded, in other words. I guess I would highlight just this portion and underline, leave blank. So, by means of transportation other than vessel, rail, or air. What's the other vessel, rail, or air? What type of situations can you think of? Truck? Okay. What else? Air. Spaceship comes by air. Unless you believe in this next Star Trek, the beam me up Scotty type of stuff. But I don't know how you can declare that. What else? What else? One more.
Oh, you're.
Happens all the time.
I guess.
How do you think we get oil? Don't you guys listen to this big thing that's very politically motivated about being pipeline being built from shale fields in Canada all the way down to the Gulf of Mexico, and President Obama is trying to not to approve it, and it's a whole big political debate, people chaining themselves up to pipes, and just you don't hear about this?
Yeah.
Okay, so people, imagine the guy got chained up and he got swayed by the Canadian air into the United States territory. No need to be declared, leave it blank. There is no port of unloading. Okay, 21. I don't have much to say about it. There is a website. There is a website that talks about goods location. You just have to put a number. One thing to note is there is this thing called general order. General order is a type of warehouse where if you fail to declare your products, your goods, your stuff within 15 days, it goes to the general order. And what they do, the general order is like a bad name, because that's a kind of like a punishment warehouse where they charge extraordinary fees for storage, and to get it out it will cost you a lot of money, and the only way to get there is because you fail to do something. For example, you fail to declare the entry. So 15 days passed, you haven't done anything, it goes there. Oh, day number 16, I want to get it out. Talk to them. Okay, general order warehouse. Something that you want to try to avoid. Okay, that's all I wanted to say about GO. Consignee number. Highlight this portion. Number must reflect a valid ID file with CPB on, highlight, Form 5106. Customs may ask you what form must be filed to get the consignee number. Form CBP 5106. So this is a company name, right? If you have a corporation, you file with IRS, this is what it looks like. If you are the big company, you may get the statistical suffix XX. So you can have number for Buffalo entries, you can have number for New York entries, you can have number for Miami entries. And that is reflected for your own accounting purposes. Social security number, if I'm doing something as a sole proprietor, as an individual. You're familiar with that number, right? And CCB assign number, that one is used when you have a foreign importer of record, such as steamship line overseas, which files entries by virtue of whatever. So you apply for the special number. So this would be foreign importer of record. Now, why is this important? Why am I wasting time talking about it? I don't think customs will ask you directly, you see this number, tell me what it represents. Does it represent corporate entity or sole proprietor? But it may be helpful when you're looking at the number to identify the entity that you're dealing with as a collateral matter, as something which will lead you to a correct answer. So just knowing that this is corporation, corporation. This is also corp. And this is individual or sole proprietor. Okay? So individual sole proprietor, foreign importer of record. It will help you to deal, because if you have this, you immediately know that, okay, they can delegate duties to their freight forwarder who is not a licensed. The freight forwarder who does business on their behalf can sub-license their activities to other people. If it's not a licensed customs broker, if it's this corporate entity, they cannot do that. They need the power of attorney. They cannot actually power of attorney to sub-license. If it's a customs broker, it doesn't matter. But it's this type of numbers, right, which may help to refresh your recollection about this type of stuff. Any questions on this? Okay, so we talk about number. Remember, this form must be filed, 5106, prior to conducting business. It's kind of like a port registration. It's your way of saying to the port, customs are gonna do business at this port. Please make sure I'm on file with you. Going back to 5106. Does customs broker need to file 5106 to transact business at the port? When? I guess when the customs broker acts as an importer of record. Because to transact business on behalf of others, remember, all they need to do is to have a license and to file a permit. They don't need that. I never needed to file one personally with GFK when I applied for my permit. But if I am doing something where I'm importing on my own behalf, even though I'm a licensed customs broker, I still need to file 5106. So in that situation, you're right, man. You do. Okay, importer number, self-explanatory. Reference number. Highlight this. It's been tested before, just this portion. The individual, so reference number, sometimes you do not want to send bills or refunds to yourself. You want it to be sent to some other entity or your subsidiary. If you want the bill, let's say there is a refund, and you want that refund to be sent to somewhere else, not the importer of record, here is other importer of record, then you would put that reference number, in that reference number, the entity to whom you want that check to be sent. That's all. So refunds, bills, notices of extension, suspension of liquidation, they do not have to be sent to the importer of record. They can be sent to other parties. How you do that? You make sure as a customs broker you notify customs where to send those notices to. If left blank, they will go to the importer of record. This is a default right there. Oh, if you're gonna do that, make sure this form is filed. Remember the laundry list of forms you have, 4811. And this is how the customs asked this question, I think a couple of years back. If an importer of record would like to have bills, refunds, notice of liquidation mailed in care of his or her agent, an accepted identification number for the agent should appear in a box labeled D, reference number. Sounds easy when you know that, but you know what? I mean, this is just a drop in the bucket. I mean, in the sea, drop of water in the sea. Try to recall that stuff. So that's how they ask this question. Okay, going back. So that's the reference number, ultimate consignee. So remember we talked about ultimate consignees as one of the players that has some kind of stake in the outcome. Ultimate consignee may be nominal consignee, may not be, but it's the guy or an entity or the company, sole proprietor corporation, that eventually gets the stuff, and they must be identified. So first, highlight this. Ultimate consignee is the person, entity to whom the merchandise is consigned. Consignment does not necessarily mean the ownership. It just means the person who receives the goods. If it is not known, so I have an importer of record, but I do not know if that importer of record consigned it to someone else, indicate to whose premises the merchandise is being shipped. You usually do that by way of looking at commercial invoice. However, you can leave it blank. You can leave it blank. It's okay to leave it blank if importer of record and the ultimate consignee are the same people. Sometimes you have situations where you have things going to different states. And one example would be Target or Walmart or big chain stores which import containers. Yes, it's one company which is headquartered, let's say, in Minneapolis or in Kansas, but it goes all over the country. So the importer of record sits in Minneapolis, but the stuff goes to California. In this case, you indicate the state, report the ultimate state of destination, so the store in Fresno, California, as known at the time of entry summary filing. Usually by the time you file entry summary, you know which store your stuff are going to, or at least you know which distribution center they are going to, if you are that big. I think that's all I wanted to say about this. Unless someone has any questions on this. Yeah. Yeah.
And this derivative, I don't know if you want to read 6.3. I don't know if you want to mention that or if that's not relevant.
Yeah, we had that before. This directive is a that's ultimate consignee at the time of. Oh no, I don't think we discussed this yet.
Okay.
Ultimate consignee at the time of entry release is defined as the party to whom the overseas shipper sold the well, I think this is useful in a way where ultimate consignee. So here it says the ultimate consignee is defined as a party to whom the overseas shipper sold the imported merchandise. So it's the party who holds the title. So ultimate consignee is a party who holds the title. Party with a title of goods for goods. But then it says, if at the time of entry or release the imported merchandise has not been sold, then the ultimate consignee. So if it has not been sold, so for example, flowers are dealt with on consignment basis. That's a general course of business. So you have flowers from Colombia being sold all over the United States or Ecuador. The growers only get paid if they sell the flowers. They do not sell the flowers. They sell them on consignment. They send them on consignment, meaning that they ship them. They still hold the title or ownership to that flowers. So this way you use a different valuation method. So I think it says if at the time of entry merchandise has not been sold, so kind of like that flower grower, then the ultimate consignee at the time of entry release defines a party of the United States to whom overseas shipper consigned the imported merchandise. So like nominal consignee or the receiver. If the merchandise has not been sold or consigned to a U.S. party at the time of entry or release, the ultimate consignee at the time of entry or release is defined as the proprietor of the U.S. premises to which merchandise is delivered. Okay, so what do you make of that? Thank you, Andrea. What do you make of that? If the merchandise has been sold, it's the guy with the title. If the merchandise has not been sold, it's the guy on the invoice. Not sold, invoice, BL, bill of lading, listed party. Usually. How can you test that on an exam? That's my question.
The question they asked me was, this wasn't on the exam, but this was one of the questions. It said, party A purchased goods from overseas intended to be transferred to party B. In a transaction like this, who's the ultimate consignee? And then they gave you a list of answers, and the two that were obvious were either party A or party B. And I thought it would be party B because the goods were going to be transferred to party B, but the answer was party A because they're the person who bought the goods direct from the overseas people. So that's how I ended up looking up this derivative because I was really confused about that. I thought. So that's how they tested it.
What's the name of the directive?
3550-079A.
Seven nine.
Yes, A.
So they can ask you about who should be the ultimate consignee if there is a problem with the title ownership. But in that case, they indicate who the owner is. So it goes back to this. Party with the title of goods is the ultimate consignee. Title that if the party is shown on a commercial invoice, it does not mean that that party has ownership. It merely is the party responsible for receiving, because it can be an agent for all I know. It can be my buying agent or my selling agent or their selling agent that is shown on the invoice. And the directive we distributed in class 2, I think, when we talked about various players involved. Okay, most of that directive was emphasizing nominal consignee. And the thing we concluded is nominal consignee cannot be the importer of record. Okay, here it's different. We have an ultimate consignee.
So the importer of the record not always be the ultimate consignee either.
Importer of record does not necessarily have to be the ultimate consignee.
Or the party with the title goods.
When can the importer of record is not ultimate, is not being an ultimate consignee? When you owner of the goods, you call me up, I'm a licensed customs broker, you call me, can you clear it in your own name, I do that, I can do that because I'm a licensed customs broker. I'm a importer of record, you are the owner of the goods. Is that legal? Yes. That's one example. You are the ultimate consignee. I'm the importer of record.
We have a question on the form. Let's say the nominal consignee list on the shipping document as important.
Okay, let's do it. Let's do it. Okay, so this is no homework, this is a flashcards. Nominal consignee listed on the shipping document as the importer. Cannot consignee act as an importer of record, and why? No.
We can use.
I said no.
Let me see. Just
The answer is no.
The answer should be no. Let's do this. Let's take a step back. No, it cannot be. So let's take a look at this. This is a okay. Let's go back. This we discussed this already. Okay. Right to make an entry. Importer of record is defined as owner or purchaser of goods, or when designated by owner, purchaser, or consignee, a licensed customs broker. So, number one, owner. So who can be importer of record? IOR. Owner. Number two, purchaser, which can be like an agent, right? My purchasing agent. Three, licensed customs broker, LCB, so long as that broker is designated by the owner, purchaser. So we have that already. So those guys can designate licensed custom broker as importer of record. But in addition to that, what we do not have here is the consignee. Consignee. What does it mean? And we had, I swear to you, I remember there was an practice exam question dealing with that I sent out. Consignee, express consignment operator.
oh yeah.
Think about DHL. They are not the owner, they are not the purchaser, okay? UPS, DHL, you name those FedEx guys, okay? They call me up. Can you clear this freight for us? We just move the stuff. We cannot clear it, okay? We have our brownies running around, but we cannot clear it. Can you clear it for us? UPS is not the owner, UPS is not the purchaser. They're mere acting as consignee, okay? Once it is consigned, they can deliver it to whoever. But so far it's UPS. They call me up, can I do that? Yes, I can. Because in this situation, UPS appointed me as a consignee, express consignment carrier. And very often what they do is they have their own brokerage departments and they clear stuff. Most of them are under $200, so they don't have to classify them. Under Section 321, which is informal. And the way it's done is they deliver, you have a bill of lading, you deliver it to customs and the customs just stamps it. And that's it, that signifies release.
So, in this question, because the consignee doesn't say it's also license.
Flora, you need to cut those flashcards.
I mean, okay.
You need to cut them out. That's why you got confused on who is yes or no.
I mean, they say why no. The answer is no because the consignee it doesn't delegate by the, licensed broker, so they cannot be the important record.
The question is on nominal consignee, right? Okay, let's move on. We haven't gotten there yet. A nominal consignee may designate a customs broker to make an entry, but may not make an entry on his own behalf. And why is that? Because if they could do that, then we would not need licensed brokers. I can designate Ethan to be my nominal consignee, okay? And Ethan, not knowing anything about, well, he is very good administrator for school, he may not know nothing about clearance. All of a sudden he is doing customs business which he has no idea how to do. Do you want that? No. So this decision has been made to make sure you actually have to use licensed customs brokers or do it on your own behalf. Otherwise, this is a runaround. And this is something, this directive has been made to clarify that no runaround should be made. Everyone sees? Everyone? Great. Yeah? Makes sense? Okay. So that's the main point, and that's the reasoning behind it. That's why nominal consignee cannot be importer of record. Okay. So can I close this one? Okay. So so everyone made a note that party with the title of goods, and if it's not solved, it's the party listed on the invoice. Okay? I'm moving on unless any more comments about this ultimate consignee scenario. This is where you put the ultimate consignee in. When I was working for the big box company, we used to put down our address, and the place where it would be shipped, we just put the state, like Idaho, right? And we were able to get away with that. It's just a state of final destination. Importer of record, name and address. I guess what I want you to do is take a highlighter out and again underline the definition of the importer of record. We've been through this before, okay? But I just want you to see it over and over, that the definition of importer of record is very important. The key point is liable for the payment of duties, of all duties, meeting statutory requirements. So if something is mislabeled, I'm going to call the importer of record, not the other parties. Okay. Part 20, column 27 or box 27. See, they switched from box to column now. Here, highlight includes net quantity, entered value, HTS number, and rate and duty. However, some line numbers may actually include more than one HTS number and value. Highlight this. This is the key part of this provision. And what it says is although each commodity has one HTS number, there are situations when more than one can be assigned. Typical example would be Chapter 698 provisions, special duty. So I have a watch. I send it for repair to Mexico because it was under warranty. And it came back from Mexico. I use two numbers. I use one that it was saying that it was repaired under warranty, and number two is that it is in fact a watch. Bless you.
Thank you.
So next, please highlight this. We're on the next paragraph. Okay, where a reporting number is preceded by alpha character designating a special program. Mexico, Canada, which is for NAFTA, GSP for A, that indicators to be placed in column 27, directly below the line number. So this is again, remember for California and Mexico, we usually name the states. But if we're going to claim duty preferential treatment, we are not using the states, we are using, or the provinces, we are using the actual country code. And directly below the line number means, so we're here, line 27, line number 001. Let's say I put 9801 something, and I put 9001 something. Right below, so this would be the line 1. Line 001, and right below it, that's what the directive says. I will put down the special code. So in here I would use MX, and in here I would use US if it was in fact made in the United States. I'm using my watch example. The watches would be, I think in what chapter? Chapter, come on guys, I ask you to remember this stuff. Watches, clocks, it's chapter 91. Watches here. So it would be 91 something. So that's what it says. This comes first, this comes last. I mean next. Not necessarily last. Okay. That's all I wanted to say about this, except also for terminology, remember that SPI stands for Special Program Indicator. Customs uses this terminology to associate it with some trade agreements or some special trade programs. So when you see that, you should be immediately aware that the special program or some duty-free provision is in question. 28. Description of merchandise. So we're here. We're in this column of 7501, and description of merchandise, what I'd like you to get out is highlight this. The way it is phrased in HTS is okay. So the way you see it in the book, the heading, subheading, the ones we saw, so article, the suits made out of polyester, other. It's okay to write it out like that, and that's the standard business practice, is just to use HTS US definitions. You can use other definitions, it's okay. I've done it before. I did the corrections by hand, so I know that there was a problem. We were importing spray guns, but somehow spray got hidden because of there was multiple provision. So what customs saw is guns, okay? And like, oh, guns. So immediately went for the examination, and then another one went for examination. We said, okay, enough guns. This is a spray guns. This is stuff you use in your own backyard for the lawn, okay? It's not the stuff you shoot people with, and because that's what customs saw, so we adopted our own methodology to better describe the product, so it wouldn't cause so much havoc. So, but if you use HTS description, it's okay to do. Mark warehouse withdrawals. Okay, any questions? I'm moving from the description to the next topic. Okay, the point to make, a full 10 HTS item number must be written. Full 10 HTS item number. I think that's all. HTS number is pretty straightforward. You have a ruling number if you have a ruling right there. But I do not have anything more to say except for declaration. I think I've seen it several times showing up. So you have, and this is the one that everyone hates because it requires the thorough classification. So here you have a set. So classifiable GRI 3B, 3C, which I'm hoping to get to, which I doubt I will now. Sorry. I think this is important enough to go through slowly. You have the products. Let's say you have you're selling this as a set together, okay? you say office supplies for back to school sale, okay, for your kids. So you have a stapler and you have a pen and you have a marker. You sell them together, and this is packaged as one. So you classify it by the most important item here, the most bulky, the most expensive, which is the stapler. And you classify everything else. You classify this and you classify that under the stapler provision. But when you report it, you report stapler out as X, and then VV, you write down, so stapler here, and then pen here, and a marker here. This is the correct way of doing it. Many customs brokers don't do it because it requires the classification of each item. But guess what? If the marker is subject to anti-dumping duties, how are you going to declare anti-dumping? Only if you break it out. Or what if it's a different country of origin? Let's say this came from China and this came from Taiwan. Yeah? This is the only right way of doing that. And it's tedious. So many people declare it just as a stapler, and this is not right, but it's a question of expediency. Okay, it says you should do this. So for customs broker examination, keep that in mind. If it's a set, you need to break it down with X and V's. Next. You have a ADD CVD case number. Remember anti-dumping, which comes back and back again throughout the day. So every time there is a case number, let's say pencils, right? They have a case number, which looks like this. But sometimes they have a case number which... So this is general. But these last three letters, they are specific to the manufacturer. They are specific to the producer, manufacturer. Because what has happened over time is when it started way back then, I'm talking about maybe 10, 15 years ago, you had a practice where one Chinese manufacturer, one Chinese exporter, was exporting pencils, let's say, at certain favorable duty rate. So everyone had to pay 108%, but that exporter had to pay only 15% anti-dumping. So what would happen is everyone would call that exporter up, can you take my pencils, can you take my pencils? So everyone was funneling through that exporter. That exporter, it was a very good position to be. It still is in some situations. I can think of one where court approved the practice of not tying it up, and that's a salmon case, in case of Norway. But with respect to China, what commerce, what the United States government have done is they said, no, you cannot do that. If we're going to give you a special number, then we're going to give you the tied rate. So only if you use the pencils from that factory, you get the special rate. But if you get pencils from the other factory, you do not get the special rate. Okay? Everyone follows? Because the anti-dumping duty is assigned on the exporter or producer, or exporter producer combination. So if I have a special rate and I go to a different factory, I cannot secure the advantage. I have to pay the general rate, which is usually assigned here. Everyone follows? I do not think you'll be tested that deep, but I just tell you because anti-dumping has been a big, huge deal lately. and it can come up. It's ever increasing, and customs may just think we should test you on this. In fact, in 2008 they decided, Andy, remember you asked me about the regulations? I think in 2008 to 2007 customs tested on all regulations from 0 to 400, which includes the import administration. So think about how much I can barely use the time we have to describe this stuff, right? Think about going back and describing the scopes, the anti-dumping procedures, and the percentage of petitioners there must be in the country before this investigation can be initiated, and blah 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 blah, so on and so forth. So they did it once, and they never done it again. Let's hope it stays that way. Okay, so that's all I wanted to say about ADD. Let's talk about the category number. Category number refers to the textile number, textile category number, or quota number, which is usually in three numeric, and it is labeled in parentheses like 666. Yes, there is a 666 quota.
Table.
No, not necessarily. If you look into the methodology, there is no scientific, there is no even theological basis for 666 interpretation, because that number can be was associated before Catholic came into big power with actually being a lucky number, I believe. I read something. I'm not a very big on theology, but 666 is not necessarily bad. Okay, category number. I guess highlight this. Textile category, okay, so it's textile. So when you see the number, it refers to textiles, not to something else. So you know immediately you are dealing with articles of textiles. And therefore, what we know so far, we know that substantial transformation has a rational tariff shift requirement, and that you have to use the manufacturer who is the actual manufacturer, who actually produced the goods. Next, other fees. Other fee HMF and other fee MPF. HMF harmonized maintenance, harbor maintenance fee, and MPF manufacturing processing fee. Highlight this part. All fees with the exception of HMF are to be reported at the line item level. You cannot report them at the summary level with the exception of HMF, harmonized maintenance fee. So here we go back to our favorite invoice. It's not an invoice, actually 7501. See the cotton fee here? It's being reported the line item level. Another cotton fee. But the MPF fee can be reported here at the other fee. That's what the rule says. Other fees block. Gross weight information must be provided at each line item. highlight this. Gross weight information must be provided each line item if the gross information is not available. Approximate shipping weight shall be estimated and reported. But the key is that each line item level. Possible question for exam: container as cargo, weight of container should not be included in the gross weight of merchandise. International shipping container. Highlight that, please. Okay, can I move on? Manifest quantity. Highlight this first sentence. Note that manifest quantity should be reported if the entry summary serves the entry in the entry summary. So if I'm not using 3461 but using 7501, I need to indicate manifest quantity. And where manifest quantity comes from? It comes from the bill of lading or airway bill. The information that steamship line or the air carrier uses. Okay, I'm skipping the net quantity in HTS US. We'll be covering more of that later on. What I want to focus on now is the entered value. Record the value for each line item on the same line as the HTS number. So you provide the HTS number, you record the value at the same line item. Because, and that makes sense because each different HTS may have different duties. And because different duties are applicable, you have to report line item by line item by line item number. Rounding. Highlight this. So if the value is $50.49, you report 50. If the value is $50.51, you report 51. Basically. Make sense? Round up or round down. If it's 50 cents, 50-50, you 51 or 50-50, what do you do? No, 51, because it says it must be less than 50 cents. Not less than equal to, less. I don't think they will do that to you. I really hope not, because when I had to take a bar exam, they did that to us. They asked us right on the border the specific question of law, and you just have to stop, think, reflect, and then answer. It gets more complicated actually. And it gets more complicated because think about this. You do this, right? But what if you have many line items and all 51, 51, 51, 51, 51, 51? You actually overpay more. Or if you go 49, 49, 49, 49, so you, for each line item, you're actually saving 49 cents, 49 cents, 49 cents, 49 cents. Can you do that on purpose? And the rule says no. If you go, you can deviate only within $1. But this is not here, it's another regulation. Very cool. We'll discuss it later. charges. For charges, highlight this. Aggregate cost of US dollars of rate, insurance and other charges. So aggregate cost while bringing the merchandise from alongside the carrier at the port of exportation, the country of exportation, placing it alongside carrier, blah blah. Okay. This relates to the Incoterms. Important, do not include US import duties. Sometimes you have a DDP shipment, duty delivered paid, you have to take them out when you report, because you are actually paying the duties. If you include duties in your entered value, you're actually paying duty twice. Your duty is included in the value, plus you're paying duty on the whole duty. So take them out beforehand. And most of the time, freight, insurance, and all other charges will not be included most of the time. So highlight from here all the way to here, please. And let's go to this question. So the question goes like this. It gives you the entry summary. We saw this entry summary. We actually started from analyzing the visa number, right? And we found out that this is Ethiopia, right? So the next question requires us to answer the total entered value in block 35 here. And we have the values here shown. Let me increase it so it so here is the value, entered value. So we have 2 or 4 possible values. So we have women's cotton blouses, right? 95, 36. Do we include that?
Yes.
And then we have charges, which we just talked about. I said generally do not, without any more information, do not include charges. Take them out. AGOA, fabric, men's cotton knit shirts. Yes, include them. Charges, don't include them. So what you have is you have 53,954 and 9536, so 0, 9, 4, 3, 6. Okay. So does it make sense to everyone? And what they are looking for is they are looking for pretty much for you to trip up on that answer D and include the freight charges. Okay, so that's why it's important to pay attention to the entered value. Relationship determines whether the parties are related. So if I'm a subsidiary of a company, or my mother is sending me a present, this is a transaction before related parties. And if that's the case, then this is not a market price. It can be the other price, or it is a suspect to be other price. So you will need to indicate yes or no if the parties are related. Okay, we talked about the visa number. IRC rate I'm not going to talk about. Visa number, we talked about it, right?
Yeah.
Okay, so I can skip that. Agricultural license number. So any of those people who use moisturizing cream, it contains, for example, animal fat. Because it has animal fat, it's a subject to the United States Department of Agriculture. So you will have you need a veterinary services permit. It will be somewhere over here. Okay. I haven't seen much testing on that, but keep that in mind. Let's see, duty and internal revenue tax. So if you have alcohol or fishing gear, it is subject to additional tax requirements, in addition to duty, to IRS taxes. And the other fee summary. Look at how many fees are there. Note the page 21. It lists all the fees that are up there. And note the codes. So you have all these fees and you have all these codes. And let's take a look. So this is an example of the customs exam question that will test you on the code. The shipment subject to fee class code R. So again, you go back to that favorite invoice of ours, and we know there is a cotton fee, right? Right here. What's the number for the cotton fee? 056. So we immediately know it's going to be either this or this. This one's we can cross out. We just increased our chances if we don't have time. And then what's 311 and what's 4999?
Merchandise processing fee.
We know we have to pay merchandise processing fee for almost every, except for AGOA and 311. What's 311?
Informal entry, MPF.
Okay, let's take a look at the value. Informal entry, we have we just established it was $60-something thousand shipment. Can you do informal entry?
No.
Okay, so this leaves only one answer, right? That's it. Knowing this, you just got one question right. Congratulations. No, because really this comes down to you knowing, you being a librarian, in other words. In this type of questions, customs says open to the right page, look up the right number, and pick the right question by association. It's not testing your knowledge or how smart you are, it's just testing the way you can navigate through this text, through this information. And if you do your practice and you know where to look for things, this should be easy. Next. De minimis. Who is a Latin buff over here? Any people who speak Latin? De minimis. How many seen this term before? De minimis. De minimis means like a minimal amount. And what it states is there are fees and there are de minimis fees. I think the way they wrote it, they made things very confusing. I think the easier way to do this is to say, and they say this, there is an established minimum and a maximum due on each formal entry. Report actual MPF. And say there is de minimis on HMF and there is no de minimis on MPF. Here's the way I would approach this. MPF. If it's a formal, it's between 25 and 485 for each entry. HMF, it's for formal. If it's a HMF, If it's less than $3, not applicable. If it's more than $3, then there is no ceiling. And there is a certain...
485. I don't know. I read it wrong.
Is it not 485? It was raised. I'm going with well, it's...
I mean, there's
20.
an old record 485. I don't know.
No, you cannot go more than 485 unless they just increased. I'm going with the stuff they will be testing you on. So it may be, they may have changed it because I know they changed the percentage for MPF. If it's in between, there is a certain percentage.
0.0036.
It used to be 0.25, 0.025, 0.0025.
It's 346.
Now 346.
5, I think.
Yeah, but listen, if they're telling you they're going to test you in a certain version of the exam, you're going to use 2.5, the old one. Makes sense, right?
Definitely.
So, but keep that in mind. This is the part
3464.
3464. Okay. Okay. Can I keep you for like another 15 minutes? Do you guys have time? Okay. If you don't have time, because what I want to do is I want to do the check digit before I let you go. You have to go? Okay.
Can I have the homework?
Yeah. Here.
Thank you.
We're almost there. We're almost there.
Is the HMF still like a 0.125% or they change?
HMF for what?
Is that still 0.125%?
For steel? For steel? Oh, I don't know. No, it's not 0.25. No, it's more. It's more like in that range.
Oh.
But on customs exam, if they tell you have to use 1 year old Code of Federal Regulations, if 1 year old Code of Federal Regulations is that 2.5, not this new one. If they tell you this, they still haven't told you. They still haven't come out. So you're actually very behind. So for me to teach you, to tell you use this would not be correct unless they make some kind of special exemption, which they haven't done. So I give you both. And I will give you both later. This is not the HMF or MPF class. It will be covered later on. Next, let me go through on duty. Make a note. ADD and CVD is not part of the duty, even though it's called anti-dumping duties. They are separate in itself. They have separate existence. Okay, I think this should be good except for one more thing. Let's go to the... Keep in mind, if you're dealing with appraisement entry, where you're asking customs to make an appraisement for you, you have to use this declaration. There is a declaration. Don't remember this declaration, just remember that you need to declare. There are few ways, very few times when you have to declare word for word something. The very first time when we came across declaration was in the context of customs broker responsibilities, where the customs broker is required to notify client, the active client, that all the checks, all the monies that the client owes to customs is the client's responsibilities only. It must do so during a time when it executes power of attorney and 1 year thereafter, every year. Okay, and there is a specific text. It cannot deviate from that text. Here is the second requirement. If it's an appraisement entry, very unlikely that you'll be tested on it. Appraisement entry is not popular. Just keep that in mind. It's very easy to remember because there is not that many things that we have to spell out word for word. within customs world. Let's see. So now we get to the appendix 1. Check digit computation. So what you will be given is you will be given an entry number and being asked to compute a check digit. So here is one entry number 0 0 M 6 2 9 0 0 4. So remember, you have seven numbers here. You have alphanumeric code. This is a broker. This is a filer code. Remember from the very beginning of this class. How this is a special formula. How do you compute that? So first thing you do, the first step is you have the M. You need to convert M to a number. You have to convert everything to a digit. What's M? You look at the appendix 1 and you see M equals 4. So that's what you do, is you write out 0 0 4 6 2 9 0 0 4. Okay, next thing what you do is you take, now you have converted everything to numbers, you take every second or every even number. So you take this number and you multiply it by 2. Multiply it by 2. What you have, so you have 0 times 2, 0, right? 6 times 2, 12. 9 times 2, 18. And 0 times 2, 0. If you have a number which is more than 9, if it's more than 9, okay, then you add 1. You have here 0, it's less than 9, you don't add 1. Here 12, more than 9, you add 1. Here 18, more than 1, you add 1. You do nothing. So in here you do not add anything. So you have 13 and you have 19. So you have 3, 9. You drop those down. You have 0 plus. You leave only last digit, 3. You leave only last digit, 9. Sorry, 9. And you drop this. And you add them up. You have 3, 9, and 2 zeros, which equals to 12, right? Guys, I'm sorry, I left it should be 7 here. I left 6. This is the entry number, okay? This should be 7 digits, this whole thing, 7 digits. So this means that here it's 8, it's also times 2. It will be 16, because it's more and it's plus 1. 17. You take out 7 and you drop it down. 12 plus 7 is what, 19? So here you have 7. So you have 0, 3, 9, 0, 7. Add them up. 12 plus 7 is 19. Right? Okay, that's the most difficult part. The next thing what you do is you take the every odd number, first, third, and etc. So this is 0. This is 4. This is 2. This is 0. This is 4. And you add them up. Equals 4 plus 2, 6 plus 4, 10. You add them up, it will be 29. You take that 9 out and pretend some number 10 comes out of somewhere. Number 10. You can have 10 minus that number, 9, the last digit. And that equals 1. And this is your check digit, 1. One more. Let's do one more. This is all written down. In case many of you try to write it down, copy it, it is part of your homework. You have that same number to work on the homework, and I have tables for you, just like I write it out here. So I think the best thing for you to do is just relax and just write down the operation. The operation is said in appendix, okay, but it's kind of cumbersome, so it's easier if you watch someone do it. So if you don't mind, can I erase it and just do another one? Sonia, yes.
The underneath 10 minus the 9, the 10 is the same 10 as the 1? Sorry.
No. This is
always
there.
Oh,
Always
okay.
there.
Thank you.
Always there. It's not. You have to do it several times. It's not.
Is it always testing?
It can be. It was tested before, yes. But it's easier. Once you do it several times, it's easy. Let's do one more. Let's do 0, 0, U, 6, 1, 2, 0, 3, 5. And the check digit. What is the check digit? What is U?
One more digit. You give us 6 only. You should give us 7, right?
61203 05. You guys, I do not know what's wrong with me. Thank you, Sonia.
It's okay.
So what is U? Convert U. 4. Also 4. Okay, not bad. So you have 0, 0, 4, 6, 1, 2, 0, 3, 0, 5. Right? Makes sense? At this one. Okay, now you go to every other one, every second one. You take it out and you times it by 2. Times 2. Okay? So 0 times 2 is what? 0. 6 times 2, 12. 2 times 2, 4. 3 times 2, 6. And 5 times 2, 10. Now, we're at the step. Add 1 if the total number was greater than 9. So here, we add 1 to 12. And we add 1 to 10. Which equals 13. This one equals 11. And we select the last digit, 1 and 3. And we drop it down for addition. So 0, 3. Everyone follows me? 4, 6, and 1. Plus, 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 plus. Equals 7, 13, 14. Okay, that's it. The hardest part is done. Next, you drop every other one, every odd number, digit. So this is 0. This is 4. This is 1. This is 0. And this is 0. Five, right? You add them up. You have 19. Then you take magic number 10. And let me show you where you take it. Here. Step 3 from 10. It just shows up from nowhere. Okay? You take 9. And 10 minus 9 equals 1. So check digit is 1. One more, and then we can go. Let's choose something which is not 1, because 1 is kind of boring. Okay, let's do this one. 0, 0, 4. No, that there is no numbers now. I mean, no letters, only numbers. 6, 3, 5, 3, 5, 2, 7. Find out the check digit. 004 is a filer code. 635 3527. 7 digits. So here you don't need to this conversion step from the letters, right? This chart, you don't need it because you have a number. So you immediately start your selection. You take this, you take this, you take this, you take this, you take this. So every other number. And then you times it by 2 immediately. Times it by 2, times it by 2, times it by 2, and times it by 2. What you get? You get 0 times 2 is 0. 6 times 2 is 12. 5 times 2 is 10. 5 times 2 is 10. 7 times 2 is 14. Okay, now you add 1 to those which are more than 9. So what you do is you have 12, which is greater than 9, 10, 10, and 14. So you plus 1, plus 1, plus 1, plus 1. You leave the 0 because it's less than 9. So you have 13, you have 11, 11, and 15. You take the last one, last digit, and you drop it down. So first you have a 0, which was less than 9. Then you have 3. Then you have 1. Then you have 1. And then you have 5. You add them up. What is it? 10, right? Okay. And then you take the drop down the other ones. So this is 0. By the way, this is a little different than the appendix shows, but everyone has its own style. So if I don't follow the appendix procedure, it's just different steps. 3, 2. Yeah, that's it. So you have 0 plus 4 plus 3 plus 3 plus 2. 12. 3 plus 3, 6 plus 4, 10 plus 2, 12. So you have 22. You take the last one and you subtract it from 10. What will it be? So the 8 is correct answer.
The second step is not start with the second number, start with the first number.
Which one?
The second step.
This one?
No, the second step.
This one?
When you do the log.
So this is step 1, step 2.
Yeah.
I only multiply by 2 every other one, every second number. Second number, second number, second number, second. Or you can put it even number.
No, it doesn't matter.
What do you mean doesn't matter? It matters the order. Every odd number. 1, 2, so in other words, you can assign this number 1, number 2, number 3, number 4, number 5, right? You, 1, 3, 5 are odd numbers. You do not multiply them by 2. You only multiply by 2 the even numbers. 2, 4, 6, 8, right? Okay, makes sense?
Yeah.
So it's not I mean, Flora, it's not so bad, right? After you went through it 3 times. After you go through it 10 times, you will feel a little better.